on profile. Pilot, I am paying leave to file one WPC without certified copy. And I have an urgency regarding no objection certificate for a medical officer who want to join in the AIMS Kolani. An interview is likely to be held on 3rd of February. Kindly fix any date.
File it first, we'll see. File with undertaking.
My lord, may I permit to mention a matter, my lord? My lord, earlier question I also mentioned the matter, my lord, and you allowed to mention. My lord, it's a matter of COST 2 of 2009, my lord, and my lord, the respondent here, my lord, he filed an application for the Honorable State Administrative Tribunal, my lord, and here was a case, it was regarding the whether the Uma Devi case will apply or not, my lord. In that case, under Title, my lord, contract order, my lord, respondent therein, my lord, filed a contempt application because the order was not complied by the petitioner, my lord. And my lord, here I am pending for the honorable court, my lord. Kindly.
Why are you not preferring a contempt? You want the same order to be passed again? Huh?
Contempt application is pending with the tribunal, my lord. Administrative tribunal.
So what is the matter here? You have filed another way.
No.
If you have filed another way, the tribunal has said you go for contempt, then what is wrong? If there is a direction, you want the tribunal and court to repeat the same direction again.
My lord, it's COST was filed with a replacement filed before this honorable court, my lord. 2 of 2009, my lord.
COST? What is COST? I'm not familiar. What is COST?
Early disposal case, nahi? Because that is non-jan. My lord, it is for the early disposal of the matter, my lord.
Like director's time now, it's
So this is arising out of the contempt proceeding. You please mention in the next week.
May I have your lordship kind indulgence to mention Milord, listed matter which is appearing as item number 12, which is our appeal, Milord.
You are the appellant.
Appellant, Milord.
12.
12, Milord. I am seeking 1 week adjournment, Milord.
The respondent has appeared.
Yes, everybody has appeared, Milord.
Is there any interim order?
There is no interim order.
1 week.
1 week.
Please intimate your
will intimate.
yes, as read by the learned advocate.
Grateful.
Item number 1.
Please, your lordship. Everyone comes with a ask you. Yes, after evaluation, I will give the original.
I beg to appear on behalf of the state.
We have. Oh.
Yes, sir.
My lord, the father of the applicant died on 16th February 2010. And my lord, the impugned order, which has been challenged on the basis of the order rejection order passed by the Joint Secretary, it reveals that the impugned order, which has been passed, not been communicated to the petitioner till the date of filing this application. Let them show a piece of paper that the order was communicated to the incumbent. My lord,
Come to page
Both-
20. Come to
What?
page 24. Come to page 24.
24.
In which paragraph you have stated that the order was not communicated to you? Please.
Page 24.
Yes. In which paragraph you have stated that the order was not communicated to you? Therefore, you are filing it after so many years. Where have you said that? After 9 years. Where have you said? Come to your OA. 24, your averment start. In which paragraph you have stated that the order of 15 was not communicated, therefore you are filing it after 9 years. Where have you said this?
My lord,
Yes.
that has not been that point has been not been taken
Very good.
in the original application which has been filed before the year. My lord, kindly see the impugned order. Page 34.
We will not look into the impugned order.
Huh?
We will not look into it. After 9 years, claim for compassionate appointment. First application belated, rejection challenged after 9 years. Writ petition filed 1 year after the rejection by the tribunal. So there is a pattern of delay.
The Supreme Court of India.
You so show the judgment that in this circumstance it can be
I
done.
will see.
Yes.
First, my lord, I will submit the actual facts of the
Not required, sir. First you have to overcome. First you have to overcome delay. Then we'll go into the facts.
My lord. My
First you have to overcome
My
delay.
lord.
Yes. Show the delay.
My lord, kindly see the applicant.
Please
applied-
don't read. We have read that. Why? Which judgment you are relying upon?
My lord, it has been referred. My lord,
Don't give one copy. Give 2 copies.
My-
You are addressing a division bench.
only one copy.
Then you keep it to yourself. You know that you are appearing before a division bench. Yes.
But I know
Yes.
to my physical condition, I could not done it. My clerk not come within the time. My lord, kindly see. Last paragraph.
Yes.
Decision. Reported.
Without affidavit, kindly send back to the tribunal.
Any other judgment? Till now. Heard the learned advocate for
Wait, am I going to take? Okay,
No, 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 no.
I will Xerox it, make it Xerox and I will submit.
Get a Xerox done and then give it to.
Item number 2.
I have heard the statement.
Resignation of a doctor, my lord, who has tendered his resignation after giving notice of 1 month. Well, this is the affidavit of service
What is the date of application?
of resignation, my lord. Now, that is, my lord, if your lordship takes up, my lord, 2/7/2025.
They filed any.
This is a new application, new motion. My lord.
Lord, may I, before the matters, my lord, this matter is under active consideration of the department. My lord, I have got my oral instruction. If it is taken up my lord, after 7 days, I can come with written
2
instruction.
weeks. We are giving you 2 weeks as prayed by the learned.
Affidavit of service.
Service is taken on record.
Next matter, my lord, same order.
Same, my lord. Same issue, my lord. Same matter. My lord, the affidavit will be kept to the record.
Item number 34.
কি হয়ে গেল? কি হয়ে গেল? হ্যাঁ, কোনটা? 4, I think 4 লিখেছি।
2, 3. 4 is different.
No, 4, yes, sir. 4 is different.
2, 3 is same, my lord. 4.
Yes. The call for.
4.
Yes. I appear, my lord, on behalf of the petition.
2 and 3 same order. What is the issue in
So
4?
the issue is this, my lord, that my father had died in the year 2011 and the terminal benefits have been disbursed to me much lately. Now, my lord, therefore, what I have prayed for is that interest be given to
When
me.
it was disbursed.
But it was disbursed. I received it on 1st August 2025.
Oh my God. 14 years.
Yes. On Lordship, may kindly see page 65. I have
Yes.
given the bank details. On 23rd of July 2025, a part of it.
And your father passed away while working.
Yes, my lord. He was passed away while
Oh,
working.
it's terminal benefit.
Yes, this is the terminal. The death benefits, my lord. Death benefits.
Oh, death benefits.
Yes.
After the date of the inquiry, one lady filed an application that I am the wife, give me good benefit. Then, after receiving the complaint, the government started inquiry. For inquiry found that that lady was not the wife. Then, US case was registered. FIR lost. Charge filed. In the meantime, we got information, filed an application, when we could not disburse it. And as soon as the traveler delivered of only the son of the first child and the daughter up to the age of 25 years. And that is, if it was handed, what are the BPO? You have to order on the drive.
Common substance to it. At page 54, এইটাতে
They took place on 31st of July for the data.
When you lost the FIR?
Yes. 2018. In the year 2000,
When you lost the FIR, sir?
2018. Sorry. Dr. Kindly sees page 54. That is the report given by the Superintendent of Police to the DIG. Yes. Lordship, kindly see the last paragraph.
2018. 428, 474.
Lordship, kindly sees, my lord, the entire fact has been given over there. And the third paragraph is very important. Thereafter said Torun Kumar Mondol expired on 31st of July 2011. After demise of the employee, one lady, namely Srimati Kajol Mondol, submitted a petition addressed to SP North 24 Parganas district claiming herself as wife of deceased employee, along with some documents, that is first page and second page of service book of Torun Mondol, voter ID card, ration card, and one copy of residential certificate which issued by chairman Garulia municipality mentioning as the wife of late Torun Mondol. After verifying, it is seen that the first copy of first and second page as submitted by the applicant is not same with the original service book. Thereafter, several messages were sent to her for appearing in this office with proper documents in support of her claim, but she did not appear. Accordingly, a legal years verification was made by IC Noapara PS, Barakpur, PS, and stated that Kajol Mondol is not legal wife of the deceased. Now, my lord, on the above circumstances, as per order of the then Senior Superintendent of Police, not 24 coordinate, not 24 Parganas and SP Barashat PD, one FIR was lodged at Barashat PS.
What happened in the criminal case?
She is on bail.
So she has not been convicted.
Not yet been convicted.
But it is also an established.
Yes.
My lord, sorry. Is it? এইটাই তো দিয়েছে তো 62
For looking into this, it took them 7 years. They have not the FIR. FIR not charge sheet. Charge sheet was filed in still till date there is no conviction. It could have been paid in 20.
My fault.
My amount kept to the bank account. In the case of bank account.
Right.
But they cannot.
They could have asked her to the service file was there. They could have asked her to give her-
শুধু দেখুন 80% change. এইটাই তো কথা।
One way difference.
This lady who had come, no nexus with me, no.
All right. So there is
And my lord,
there is a reply filed before the tribunal.
reply to report was filed. This report was.
Where is the report?
Well, this is that report.
This is the only report.
This is the only report which they had filed.
Yes,
But-
Mr. Mukherjee. It doesn't appear so. This is a letter addressed to the DIG by the Superintendent of Police. This is not a report.
এটাই তো দিয়েছিল, আর তো কিছু দেয়নি। And my lord, a clearance certificate was.
Sir, we are asking you a question whether reply or report was filed. Please be specific that it was filed or it was not filed. There's no point in unnecessarily arguing everything and then giving them a time.
My lord, one status report was submitted, my lord. I have only one copy, my lord. This is the original. The status report. Annex copy.
Is it part of the brief?
No,
You give him a copy. You give him a copy.
my lord.
The
Survey copy, permission.
Just give him a copy.
My lord. Obliged, my lord. Grateful.
Item number 5. The 5, my lord, I am for the appellant petitioner, my lord.
My lord, I am for the writ petitioner opposite party. Well, last occasion, your lordship, my lord, directed me to uh, bring decisions regarding delay.
No, lord, that was no direction for my lord, the using affidavit, my lord,
Yes,
in
yes,
response to my,
yes, evidently, my lord. Your lordship kindly.
my lord, in that even, my lord, I may be granted liberty to
An
file reply.
affidavit of opposition.
Can 1, section 5. Your lordship, my lord, asked me to bring decisions, 840 days delay. So I have bring all the judgments. Ready.
Item number 6.
I was for the appellant. State government has preferred this appeal. Now, earlier, copy of the section 5 application as well as appeal was served upon the writ petitioner respondent as well as the school authority. School authority received, but the in case of the writ petitioner, it was returned back. The addressee left. Your lordship asked me to serve it to the school itself because he was serving. I served it to the school itself. Again, it was returned back with the remarks. Addressee left without intimation. So either he transferred elsewhere or in the meantime he retired. Maybe, because
So what do you propose, sir? How to ensure that he is
I shall affirm an affidavit to that effect. Only not today, tomorrow. Can you take it tomorrow? I shall affirm an
No,
affidavit.
but at the same time, something will have to be done.
Yes,
So you
that's
think
the
of
whole
both
difficulty.
things. You think of
But
both
I
things.
asked the DI to ascertain whether if he is transferred to elsewhere, kindly supply me the school where
You
presently
are
he
the
is serving.
state, you should be knowing everything, where he is, what he is doing. For you, it is not difficult. Even if he is on transfer, you should know. If he is retired, from where he is getting his pension, that also you should know. So for you, it should not be
But
difficult.
the address, in his residential address is so left. The school cannot say if he left elsewhere.
But see, that residential address would correspond to his posting. So that will change with his posting.
Again, I shall try.
So you have to find out from the authority.
Again, I shall try.
The learned advocate for the appellant.
Item number 7. Item number 8.
My lord, in item number 8 and 9, Mr. Arnav Chaudhary is appearing for the appellant, my lord. Due to medical emergency, he has not come to court today. I'm praying for an 1 week's accommodation, my lord.
Not today, we'll bring it on Friday. This Friday. As prayed by the learned advocate.
I'm great.
Item number 10.
The matter today is nobody here. There's some resolution or
Today, Jalpaiguri inauguration is there.
what is there?
The Jalpaiguri bench of that inauguration. No, no, 11
Inauguration.
The invitation was sent by mail ballot. I don't know, that may be, not know, my lord. A facilitation ceremony would be held in Jalpaiguri, my lord. That one link has been provided in the my lord e-court services note that is there. No, no, আজকে আছে 11
Lawyers went there.
No, my lord, there is a link has been provided. My lord, some may, my lord.
But that has started from 10 a.m. The none appears on behalf of the party.
Item number 11.
All these matters same.
Is same dismissed.
Board is functioning outside. Is the display board functioning?
Item number 13.
12 নামটা দিয়ে মেনশন হয়েছে
First order.
No, I mean 12 appearing for the CBI.
Lawyers present submitted.
মেনশন হয়েছে নোটিশ ছাড়া মেনশন হয়ে গেল
No notice has been served. We do not know what.
But I have to appear with the state respond.
What is the order into that?
But
I am appearing for the CBI.
And this morning, it was mentioned for an accommodation and he assured us that he will be informing the other side. We didn't know the case. There was some difficulty, so we have adjourned it.
Well, we are not standing in the way.
Then, my lord, let our appearance be noted, my lord.
Yes, please give your opinion.
Because it has been, my lord, on the second, my lord, date was fixed, my lord, copies have been supplied and the next date is fixed, my lord, in the 23rd February, my lord, for inspection, my lord. Practically, my lord, for inspection of the documents supplied, my lord.
Now we recollect. You said that now it has perhaps become infectious.
Yes, that's right, my lord. This is CBI, my lord, took over the investigation and charge sheet was filed, supplementary charges were filed, and it copies have been supplied. And next date is, my lord, for my lord, inspection
If
on
you are
23rd.
objecting to the adjournment, give your appearance. When he's here, we will consider.
18th April. 18th April.
Item number 13.
My lord, I am appearing for the appellants, your lordship. My lord, Mr. Bihani is leading me in this matter, my lord. He is engaged in other court, your lordship. I am paying for a day's accommodation.
Cannot be adjourned on every date, matter. Let us see, he will come if he is on it. Let us see what is the issue.
বল না না করতে পার তুই বল যে আমি ডেট পাই
My lord, I'm led by Mr. Bihani, my lord. He's here.
ডিটেল একটা মেমো তো একটা রিড রিকলিং অর্ডারটা রিকলিং পিটিশনটা ঠিক আছে ডিটেল অর্ডারটা এটা মেমো তো এটা ডিটেল অর্ডারটা কোথায় দেখ ঠিক আছে কি বললো জজ কোনটা করছে
হুম।
বিফানে কি করবে এই অর্ডারটা কিন্তু ডাউনলোড করবে
Yes.
Now, my lord, I must, before starting with the merit, I must admit to your lordship, brother, there is one, I've just been engaged, I find that there is one fallacy in the appeal, in the sense that your lordship will still find that the order in the writ petition was passed on 1st August 2024. Well, I find from the record and speaking to my junior that thereafter, my lord, the recalling application was taken out by us. And the order of recalling, my lord, was passed on, my lord, 2nd September 2025, rejecting the recalling application. But an appeal should have been preferred against this. Nothing has been done as yet.
Plus, you have not filed any.
There's only a memorandum of appeal, no application preferring stay on anything supporting it.
No, there is no application.
There's no application supporting
for
it.
condonation also.
Condonation of the I've seen that. Well, there's a fallacy. That's why I started with this submission.
So you take steps.
Well, kindly adjourn it for 2 weeks. Let us take, my juniors take steps.
As prayed by learned advocate for the and or otherwise. And or otherwise.
Item number 14,
Lordship, I am for the respondent bank led by Mr. Buidujo Ghoshal, Lordship. Lordship, in this matter, we don't have any copy. No copy has been served yet, Lordship, upon us.
Yes. What is the appearance? None appears on copy.
Item number 15.
There is this.
Previous matter, the absorption was made. Absorption was made.
Item number 16.
Actual employee 79. What is the Labor Department notification? Need a train. That is factory completion. A correspondence was made. So everything like Japan. Good case. Good case.
16, my lord, I am for the respondent, my lord. On the last occasion, my lord, my learned friends, my lord, where my lord instructed my lord to come back with instruction, directed my lord to come back with instruction, so far as my lord withdrawal of the appeal.
My lord, we are still awaiting instructions, my lord. Kindly give us short accommodation, my lord. We will.
Not today. Come on Friday.
Good.
Item number 17.
My lord, I am for the appeal. And my lord, on last occasion, I had mentioned that advocate on record is injured on his leg. He is not recovered yet. One. I'm paying for 2 weeks at accommodation.
By way of last indulgence, the matter please make arrangements. Don't seek an adjournment again.
Item number 18.
But I appear for the appellant.
I am for the respondent. Respondent writ petitioner.
Writ petitioner and state. You are for?
Well, I am for the appellant.
Appellant is
Appellant municipality is before your lordship. The state is, my lord, my learned friend is appearing for the state. Lordship, may kindly recall, my lord, this is this matter where the municipality had entered into an area where there is a pond of the writ petitioner respondent.
for beautification they were taking
My
on
lord, I
some
was taking steps, my lord. My lord, I have candidly, sir, my lord, I have not taken steps in terms of the Inland Fisheries Act. The Inland Fisheries Act says if someone is, my lord, making any construction or creating any filth in the water body, then the municipality has to take steps in terms of section 17. I have to notify him, hear him, and then thereafter I have to take steps. In fact, without any notice, my lord, I was taking steps for the beautification. The police authorities, my lord, submitted a report before the honorable court, single judge, my lord. I also submitted a report before the honorable single judge. I said that I am taking steps for beautification of that area. There is a temple, there is a trust, Kalimata temple trust. I was taking steps for beautification. The police authorities said that it is the trust who was in fact trying to encroach over that water body. But the honorable single judge, while allowing the writ petition, restraining me from not interfering with the water body, I will not interfere. If I have to take steps, my lord, I will take steps in terms of section 17 has imposed a cost of rupees 5 lakhs upon me, my lord.
5 lakhs.
5 lakhs.
Yes.
Lord.
Let us see. Where is the report of the police authority?
My lord, the last occasion, my lord, I submitted the report of the municipality, and your lordship has called for the record of the honorable writ court, my lord.
Paragraph 15 onwards of the impugned order, my lord. Everything has been detailed in the impugned order.
Let us see the impugned order. Paragraph 15 onward.
In fact, paragraph 14 has quoted section 17 of the Inland Fisheries Act. My learned friend is right. Paragraph 15 onwards, my lord.
Prior to that, submissions are recorded.
Just bear with us for 5 minutes.
Just bear with us for 5 minutes. There is no bank. Bank bed nahi hai.
So who is the writ petitioner?
Is it?
Who are you? How are
Owner of the.
Is
I am the. I am
owner
the,
of the pond? You own the land.
Yes.
And what is your relationship with the temple?
Nothing.
Nothing. The
They have trespassed into my property.
temple has trespassed into your property. That
was
is
his-
your case.
That is was his allegation in the writ petition. The municipality. The temple committee is there, my lord, under the my lord, under the instigation of the temple committee, the municipality, my lord.
You have no concern with the temple.
No, no, no.
No, that we have seen. The committee is respond number 8.
Eight.
Number 8.
তোমার সেকশন 17 কি বলছে?
Yes.
No, my lord, the reports
Where
were,
are the two reports?
there are two reports, my lord. My lord, it was there, your lordship has asked for the, but on the last occasion, my lord, I submitted the report on behalf of the municipality, this one-page report. And the state, my lord, had submitted this report. But there is one-page report, my lord, possibly it's in this appeal file, my lord.
No, there should be one by the police and there should be one.
The police, my lord, I have brought it today. This is by the police authorities. আর কপি আছে তোমার কাছে মিউনিসিপ্যালিটি আমাদের রিপোর্টটা সব রকম ফাইলে দিয়েছিলাম এক পাতার রিপোর্ট যেটা আমাদের আছে আমাদের রিপোর্টটা একটু বার করে দেন এক পাতার রিপোর্ট যা সবের ফাইলে আছে না না সেদিন আমি দিয়েছিলাম আবার
And your report?
My report, my lord, I handed over to your lordship on the last occasion, my lord. It's in the appeals file. My lord, this is one-page report. I have only one copy.
No, if you have given it, yes, it is here.
Well, to verify these reports, kindly go through page 15 of the writ petition, the photographs at that point of time. Page 15.
It is page 33 of the stay application.
This was the manner in which, my lord, they invaded into my property. Despite repeated representations.
They were, my
from
lord,
all
in
the
fact, they were, my lord, filling up the water body. It was filled, filled of filth, my lord. And there is no embankment, my lord. It is a busy thoroughfare in Bardwan area. This is famous Dr. Pada area. There are around 200 doctors. People move around it.
If your
It's a
lord-
busy thoroughfare. There is no embankment. I committed a crime, my lord. I should have notified him under section 17, took steps in accordance with section 17 that why are you not creating an embankment? Why are you ruining this water body by putting all those dust and filth? I should have done that. I have not done so. I have not done so, my lord.
If your lordship sees the report
But my lord,
of the
my lord, today, my
municipality,
lord, I am only on, my lord. I will not, my lord, because the honorable single judge has rightly restrained me from entering into the water body, my lord. I will not do so. But I'll take steps in terms of section 17.
Direction has been issued against respondent number 8.
No direction. Only against me.
my lord, the municipality took the responsibility of this job. Municipality in his report also admitted, and my lord, in his statements also, my lord, they said that the work is being done by the municipality.
No.
So if you want, we will accept the municipality's report.
Municipalities, if your lordship sees.
You are relying upon the municipality's report.
No, I am only, my lord, I am only interested with the, my lord.
We are only concerned with the cost.
Yes. He is there.
He is only concerned now. The municipality report, if you want us to rely on, we will rely on.
I'm not asking, my lord, I'm not submitting for relying on the report.
So see, the situation is like this, as we can gather, subject to what submission you may make. There is a complaint by the trustees saying that you are abusing the property. You say the trustees in connivance with the municipality and they are abusing the property. And actually, there is a dispute regarding ownership of the property between you and the trustee.
No.
There is.
There is no dispute with the ownership.
There is. There is. It is very apparent in the police report.
No, trustees, my lord, did not. My lord,
Sir,
did
you
not
please
dispute.
read the police report. That was part of your writ petition. There is a dispute regarding ownership between you and the trustee. We don't know whether it has led to filing of a suit yet, or it is just
Nothing.
maybe not, but that is the police report. So even if these photographs are taken on the face value, it does not show filling up. They are saying we are cleaning, so they are using that earth movers to clean it up.
They had.
If you don't want, they will not do it, or if they will do it in accordance with.
Seize the photograph. They were
Yes.
making structures. My lord, kindly seize, my lord, my lord. They were what they were doing, filling up the, my lord. Initially, they.
This photograph cannot be taken to assume that any filling up was being done.
Seize the report, my lord. May I first go through the report, police, my lord, because
We have read
there is
both
no
reports.
dispute with
Therefore,
regard to the title.
oh,
Title.
please read it then.
There is no dispute.
Yes, please read it. Please read the third paragraph. Please read it out loud.
Accordingly, as per endorsement.
Yes.
Aforesaid grievance petitioners, petitions of petitioner S.I. Abdul Hasim Hazari inquired into the matter locally. During inquiry, the EO had met with the petitioner Subhajit Das and alleged persons, namely Pradeep Mukherjee, chairman, Fauzdari Mata Kali Trust. The both petitioner and alleged persons had claimed the aforesaid scheduled land as their own, which leading to a dispute between them in question of its ownership.
You are saying it, there is no such report. When we say we have read, then only we will say we don't know anything.
No, well, the ownership is not
It is of Bardhaman, it's not local that I can acquire knowledge in 2 years.
Well,
So when I am making my observation.
My lord, no, my lord, this is the report of the police.
But this is relied upon by you.
The trust appeared before the court.
We are not on.
their case.
We are not on that.
It is not.
We are on what kind of sin they have committed to be saddled with 5 lakhs cost.
Now, my lord,
We are only on that.
lordship. Now, my lord,
They are saying fairly that whatever steps they will now take, if they will take in accordance.
they have restrained themselves. My lord, now it is not. Now, my lord, why, my lord, my humble submission before your lordship, my lord, that this, my lord, usually, my lord, in matters, my lord, matters.
Otherwise, they are not disputing anything. So therefore.
Now, my lord, I understand. My lord, my only submission is this.
Otherwise, if we reopen the issue,
yes,
we don't know what will happen.
Lordship.
Because there are 2 reports of 2 authorities. One of the reports suggests a dispute on possession and title.
My lord, respondent number, well, if your lordship comes to the impugned order, my lord, there is no whisper. My lord, respondent number 8 appeared before the court. There is no whisper about the, my lord, claiming of ownership or title.
That is the report, sir.
My lord, respondent number 8 appeared before the court.
The respondent number 8 kept quiet.
No, my lord, if your lordship sees, my lord, if your lordship sees, my lord, Mr. Shah appeared, my lord, kindly sees.
Yes. What has he said? Please read.
Paragraph 10.
Please read.
Mr. Shah, learned advocate appearing on behalf of the respondent number 8, however, submits that an appropriate order may be passed so that the cleanliness of the area in and around the respondent number 8 temple may be maintained.
So that is their only anxiety.
He didn't claim the ownership of the property.
Because the only issue was whether somebody is interfering with the land which is supposed to be a pond or depressed land. That was the only issue here.
But that is recorded pond, my lord. There is no dispute.
No reason for imposing this kind of a cost. 5 lakh rupees cost.
My humble, my lord.
Either they are liable to prosecution, they will face the consequences under the statute, or nothing. Where is the question of a cost?
My lord, the nature and character of my pond, my lord, that has been changed.
Where have
I
you
had to restore it.
Where have you said in the writ petition? Please show from your writ petition that nature and character has been changed. And this judge has not recorded any such finding that it has been changed.
No, my lord, it has. May I take your lordship to the impugned order?
Please. First show where you have said, then we will see whether there is a finding.
In the writ petition?
Yes.
Lord, paragraph 6 onwards.
Yes.
That of late. That of late.
Onwards till 10.
So may I play that of late around the last week of March,
Sir, we are asking you
2025.
just show us that one line that they have changed the nature and character of the land. Where have you made this statement?
Rampantly working on his said water body by using excavator and other means and have apparently taken complete control over the same.
That is not change in nature and character.
Well, excavation has been done.
Excavation, they are also saying that we are doing it because you have made it filthy.
For
They are
that,
saying, they are not saying that they have not done it.
well, they have their initial. Well,
For
if you are-
cleaning up also, they are required to take steps in accordance with section 17.
Yes.
Where is
That
it?
was the
Show,
submission, but
please show us.
kindly comes to section 17.
Yes, it has been quoted in the order.
Yes.
And the judge has,
That-
single judge has found violation of 17A1.
That was the.
So what is 17A1? Come to 17A1.
No person shall not page 81.
17A1.
No
Yes.
person shall put any water area, including embankment, which is capable of being used as fishery, or any naturally or artificially depressed land holding which retains water for a minimum period of 6 months in a year, to such use other than fishery as may result in abolition of fishery within the jurisdiction of any municipality.
Where is this allegation?
My lord, I am coming to it.
Where is this allegation?
My lord, my lord,
You
the
are
law
saying
says,
they have used excavator.
My lord,
They are
law-
saying we
my
have
lord,
cleaned it up.
May I submit, my lord? Law says that I am not supposed to fill the water body. I am not supposed to keep it unclean.
That is for you.
Yes.
Yes.
And if I do so, then, my lord, the law says that I should be put on notice. Yes, but that is what I'm showing, my lord. I should
The
be
law
put on
says
notice.
what the
My lord,
law
may I
says.
may I be
Yes.
allowed to come on that, my lord?
See, before they take over management, before they take over control or such action, control of the pond and embankment, they are required to give a notice.
Yes.
This is the mandate in the statute. We don't know. There may be various judgments interpreting it till now, but what we read from the provision, that is what is there. Now, the other aspect is beyond that, they are the competent authority. Can it be said that it circumscribes their power to maintain cleanliness of the
Lord,
pond?
they cannot take law in their own hands. That is the reason for which the under single
That
judge
you
has-
may perceive,
No, it
but
is
there
not
has to
perceived.
be a
It is very
factual,
much-
that has to be a factual foundation for saying that they have
That is
violated.
an admitted fact.
All right. So show the admission first. There is no allegation. Where is the question of admission? There is no allegation in the writ petition that they have taken control.
My lord, I have shown it right now.
You may think you have shown. We don't see it. We have been asking you to show.
My lord, I am showing the
First, you said nature and character has been changed. No allegation in the writ petition. No finding of the honorable judge.
They have taken control of my
You have not said that also.
constructions reports are there in the police report also, and my municipality also.
So police report says nothing. It says there is a dispute going on and they are just cleaning up the place.
No, they are making construction. Police report said.
Read.
The police report.
Hello, police report. Is the third paragraph.
PS records, it came to light that on 26/4, received one petition from instant writ petitioner. The same petition was received at Bardhaman PS superintendent, alleging that some individuals under the patronage of Bardhaman municipality unlawfully took control of his pond. Accordingly, as per endorsement of the aforesaid, the both petitioner and alleged persons had claimed the aforesaid scheduled land as their own, which leading to the dispute. In course of physical visiting of spot, it was noticed that an ongoing construction work is being carried out.
Yes.
On the scheduled dispute.
By
CC Fauzdari Kalimata.
Huh?
CC Fauzdari Kalimata.
By
Trust.
Therefore, we asked what is the direction against this pond number 8, sir?
So that, my lord,
Please, we made this observation at the very beginning.
I am
After reading the reports, we asked you what action has been taken against this pond number 8. Regarding them, what is the finding? That they should be paying a 5 lakh rupees cost. We are only on that.
because the municipal, my lord, this is a matter only relating to cost. Well,
This
so far as
issue-
the grievance is concerned, my lord, that has been satisfied. So now, my lord, is the discretion of the court, my lord. The court has awarded cost, my lord. I am to justify as to why it has been treated as a special case.
That's why we are hearing you
Yes.
whether you can justify or not.
No,
Till
my
now,
lord.
we are prima facie
Justification-
not convinced.
Justification varies, my lord,
Yes.
from court to court, my lord.
No justification. See, there is no arbitrary discretion in any court.
No.
There has to be a factual foundation on the basis and a premise for awarding
In that
cost.
event, that is what, my lord, I am trying to, my lord, satisfy your lord.
There is no finding regarding them. There is a finding that respondent number 8 is doing this. In their report, they admit that we have excavated for cleaning.
Yes.
So what is it? That a 5 lakh rupees cost should be awarded to them? And they are, on the other hand, their better sense is prevailing. They say we may have been misled by respondent number 8. In our eagerness to maintain,
That is where, my lord, I am on.
may have been, we have not, we don't, yes,
I take it on that way only.
they may have.
Leaving apart the, my lord, the factual aspects.
There is no.
My lord, if an act is done in good faith, my lord, it is appreciable. My lord, this is a case, my lord, where though the appellant, my lord, tries to impress upon this court that this is an act done in good faith with all bona fide, my lord, it is an instrumentality of the state. Now, my lord, the state, my lord, is supposed to act within the four corners of law. My lord, here, my lord, the state, my lord, when he is moving this appeal without going into the merits of the appeal, my lord, only on the cost, my lord, he is making his submissions. So, my lord, factually, they have admitted that, my lord, they have not done something which is in accordance with law. And there is a gross
They
violation.
have.
They have not done.
See, they are a state. So they are bound to take a fair stand. They are not a private litigant.
No.
So they say that, yes, we have excavated because there was complaints of filth being thrust in the water body for maintaining cleanliness, for beautifying, we have done.
My lord, even for a
They
just
say so,
cause, my lord, even
but
for
they
a,
say even if while doing this, we should have issued a notice. That we will do
my
now
lord,
if
this
required.
issue, my lord, my submission is rationally or justification does not obviate the rule of law.
Sir, therefore, again and again, we are asking you one thing.
My lord,
There, you have not made any specific allegation against any authority there, any individual. Your whole allegation is that respondent number 8 has turned the handle.
yes.
Can a finding unilaterally be recorded against them? Therefore, we asked you in the beginning, how is it possible?
No, that is not the petitioner's.
That is the whole thing in the writ petition. There is nothing else.
But the petitioner
That respondent number 8 has instigated, and the Honorable Single Judge finds nothing against the respondent number 8.
My submission is limited.
And you say that, yes, they are culprits.
Is limited and confined to this manner that I am entitled to some cost.
All right.
I am not, my lord, pointing out my finger categorically that no, the trust should not.
So you have failed to show any connivance, any finding against respondent number 8.
My lord,
Against respondent number 8. In absence of any finding against respondent number 8, how your case was accepted by the Honorable Single
my lord, I have suffered, my lord. My property.
You may have suffered.
My property has been trespassed.
Only because better sense has prevailed in them, you have succeeded.
My lord,
They
have
have.
take law in their own hand, my lord, without following
You may keep saying that, you may keep saying that, but they have come before the court and they have taken a fair stand. Therefore, we are of this view.
So,
They could have opposed it. They said that, yes, they told us that there is something going on. We excavated, we cleaned it up. The Honorable Judge does not record any finding regarding any connivance with respondent number 8. The Honorable Single Judge does not record anything about respondent number 8. Then how they can be at fault? Your allegation in the writ petition has not been accepted.
If they are not at fault, may I take it in this way? Well, so far as the cost part is concerned, that is one thing. If they are not at fault, so then my writ petition should have been dismissed.
See,
I will not argue further. This was cost
that
part
stage is not over yet. That stage is not over yet. Everything is before us.
Lordship.
Therefore, we are asking you whether you can show from the Honorable Single Judge's order if there is any finding recorded regarding his connivance with respondent number 8, and what is how the respondent number 8 has been saddled with any consequence for doing this.
That has not been done.
Then where is the scope for cost? That is what we are saying. They have admitted that they have gone into the water body. There is a dispute. They say we went for bona fide purpose. You said no, it was on instigation.
My lord, may I submit one thing, my lord? My lord, I got the mind of this court, my lord, but I will not argue further on the, my lord, the issue of cost as to who is responsible. Now the question is, my lord, whether, my lord, in this given case, when, my lord, my property has been trespassed into, and that is apparent by respondent number 8's instigation, or my lord, the municipality has done whatever, the police authorities had a connivance with the municipality. Now, my lord, wrong has been done to me, my lord, that has been undone. Now, my lord, that has been stopped.
That is your property.
Yes.
But that
I
property.
had to destroy it and I am entitled to some cost.
But there is a statute
Lordship.
which mandates maintenance of that property in a particular
That was
way.
done. That is what I am trying to show your Lordship. my lord.
According to them by you, and according to you, they have interfered.
No, my lord,
It's not an interference with
may I
private
take your Lordship for a moment, my lord, to the statute? My lord, that was the impression of the learned signature. My lord, initially, my lord, may I tell your Lordship?
17A1, please read.
Lord, 17A1 has to be read. The entire 17A has to be read.
Finding is only regarding 17A1. You have not challenged the order.
The other provisions are also there.
You have not challenged the order. The
I
finding
have not challenged the order. Even
is
17
only regarding violation of 17A1 and nothing else.
17A1 has been violated, and thereafter 1710 has also not been complied. My lord, everything has been dealt within the order.
Because 17A1 has been violated, compliance is required with 10. Otherwise, it is not required.
Yes.
So 17A1, where is the violation?
Violation is, my lord.
What does 17A1 say?
Yes.
Read.
May I take your Lord's word?
Huh? What happened?
I say that he is pressing hard upon this cost.
No.
I don't want to make any submission.
But I say, my lord, but in that event, my lord, I shall not argue any further. I shall not argue any further. If it annoys the court, my lord, I shall not. I shall not. I shall not argue.
Question of annoyance.
Because I am also an officer of the court, my lord. I should not.
It is a new act for.
I should not.
Speaking for myself, I have seen it for the first time. And the intention is obviously the intention underlying all the provisions, all the proceedings undertaken for it as a green initiative.
Yes.
That you are more in the nature of a trustee of that land to keep it in the way it is.
Right.
Even you cannot fill it up.
Yes.
Yes.
That is the law.
Even the owner is the trustee of the water body.
You have seen
And
it.
if I do so,
You are in the nature of a trustee for the future generation.
Future generation, environment, and everything. And for my lord, the law, my lord, law prescribes that if I have committed something wrong, then my lord, the authority.
That's a very.
Yes, everybody.
We have seen the
Yes,
intention.
everybody. Everybody. Now, my lord, I am supposed to. I am supposed to be put under notice.
Have the ballot.
If I do not comply, then the authorities will take over management and they can do everything.
They are admitting.
My
They
yes.
have.
So what
Yeah,
they,
my lord.
What
now,
they
my
are
lord,
admitting is
behind the back, what happened, my lord? May I tell your lordship? I am not on the cost. These projects, my lord, these renovations and all, my lord, there are, my lord, money is to come. Your lordship also knows. And my lord, they.
What money? We don't know. Tell us.
No. For the
My lord, my
scheme,
learned
this
friend
scheme-
appears for the municipality and briefed in this matter, my lord. This is my lord. This submission is being
Projects-
made from the bar
Yes.
with regard to money and everything.
No. Why I am saying
My
so?
lord,
Money for what?
for
What was money for renovation?
Huh.
Scheme, government scheme.
government scheme.
Yes, schemes of the
You mean
government.
money comes. This is
No, money comes with.
This submission is being made from the bar.
the legally.
I am not saying about illegal money. My lord, I am saying about the schemes.
Legally recognized.
Yes. I am saying what I am saying, my lord, how it operates, my lord. These schemes are there, my lord, for renovations of this.
You should take advantage. Get it beautified.
I'm grateful, my lord. That is what we are.
Those stages are over. That's why, my lord, we came, my lord. It is not the luxury of the litigant, my lord, to come up before this court and, my lord, contest these matters. And that too, my lord, against the state.
If they are cleaning
It is
up
not the
and
luxury.
fine.
Repeated representations, repeated persuasions. The client went from door to door to all the authorities. Those things are there, my lord. My lord, it is not the luxury of the client.
Can we have a copy of the act? Do we have?
My lord, I have.
Lord, I have.
West Bengal Inland Fisheries Act, my lord.
Just make a note. We'll get it through the library.
Even the police authorities.
So
Yes.
if it is over, we'll pass the order.
And if your lordship kindly sees the land laws, land laws এটা non-number value में पाया जावे. West Bengal laws non-number value में.
On Friday we are keeping.
Friday.
For my sake, I want to go through the book. Get a copy of this.
Lord, when, my lord, Mr. Siddiqui's argument is only on the cost, not on the merits. I am also not supposed to, my lord, when the court is not inclined, my lord, it is.
Unless you say that you don't oppose it, you will have to pass an order.
No.
So therefore,
I am opposing. I am always opposing. Subject to your lordship's
Look
sanction.
at the act.
Lord,
Therefore, we are.
come back.
Lord, we'll come back on Friday.
Yes.
Grateful to you.
Item number 19.
Well, I am for that.
I'm appealing for the CI.
It's the APD service. Yes. Page 209, the order. My stay application.
It is a stay application.
Yes, 209.
There is no condemnation application.
No.
Why?
Condemnation. Lord, subsequently, this order has been corrected. Well, kindly see page 227.
227.
Yes, yes. Well, from already 10th April 2025, the order has been, there is so many typographical mistake. So that's why the order has been again corrected by the.
Therefore, the office of court should be ignored.
Yes, kindly see page 227.
You're required to file an application, sir. What are you saying?
Because I am paying leave to file. Get.
Item number 20.
Well, I am for the petition. This matter was heard at length, my lord, on 20th January, my lord, may I take your lordship to the last order passed by this bench. Compassionate appointment, my lord. A recent order was passed that was challenged. 20th January's order, my lord. Detailed order is there. Some instructions were sought for from the state.
Kimter. ওই কোথায় কথা কপিটা দেন
Yes, is there any provision?
Relaxation power has to be, application has to be made.
No.
If they want a relaxation of qualification, then government can consider. Because they are bound by the rules. Maximum age is 40.
40 and 8 standard.
You have the last order. Please read para 7 and 8.
Yes. But when eight to eight.
See, there are two things.
Yes.
One is overage, other is age.
Age, first,
Education.
Education coefficient.
So age we have already recorded that it has to be determined with effect from the date on which his father died. Because you have considered it belatedly, that will not go against
Yes,
him.
but coefficient.
So therefore, again we are asking you, please read para 7-8 before you start making forceful submissions.
Refers to AP number dated 3rd December 2013 within Note B, clause 6 contains provision which the education coefficient may be deducted in eligible cases. They will encourage whether the provision and other existing providing manner of cases contemplated under BB.
Who is eligible? Whoever the authority thinks, or there is any guideline, any procedure saying who is eligible for relaxation.
But under the scheme,
where is it? We have asked you to come with that. It says eligible case. Eligible.
Eligible means two things. First, within the parameter of age, and second is the education qualification and income group.
It is not, sir. It is not. This is only for education. This is not for age.
Or any age, but age can be relaxed.
It is not for age. It is for education.
Education, class 6 pass. But under the rules, he must be a 8 standard.
Who doesn't know? Is he saying that it is not required? Who is saying not required? Are we suggesting that that 8th pass is not required? We are saying your rule says, your policy says that is relaxable in eligible case. So who is eligible? Who will be considered eligible? What is the ground for looking into whether he is eligible for education relaxation or not?
Under the scheme, but the ultimate authority is the government.
So whatever they want.
No.
Because somebody is having fair skin or dark skin, he can be given.
Page 42, by passing there. On 2 grounds, application was rejected.
We are not on that. Please don't make those submissions. We are asking you, we have asked you in paragraph 8.
Yes.
You say in eligible case, educational qualification can be relaxed.
Yes.
So who will be considered eligible for relaxation? What is the criteria for relaxation? Where is this criteria? Is it fully arbitrary?
No, certainly not.
Then where is it? That's what we have asked you in paragraph 8 to show. You are making
Note B.
Huh?
Note B.
No, it is not. You please read, sir. You are not reading. That's the whole problem. You are only interested in making submission that he is not eligible. He is not saying that he is eligible.
Whether there is any executive instruction so far.
Otherwise, can you say that he is wearing a white shirt, so he is eligible?
No.
And because he is wearing a blue shirt, he is not eligible?
No.
So who will be eligible for the relaxation?
If he fulfills other conditions, then he must apply before the government that because of this pendency of this application for a long time, can he relax my age and
relax my age? Where is the question of age? It's a question of education. Education qualification.
Education qualification class 6 standard. But the recruitment rule said.
So therefore, is it your case that even if he has not got any educational qualification, he can be appointed in appropriate case? A person who is illiterate, then he can also be appointed? If the secretary thinks that yes.
No, but according to the rules framed by the.
Where is it? Where is the provision for relaxation? We are trying to gather this from the last date. Again, today we are on the same page.
According to the rules framed by the government under 309, the candidate applying for the group D post of 8 standard.
But here,
All right, therefore there is no provision. It is left to the arbitrary discretion
No,
of the
certainly not.
secretary to decide. We'll decide on that. We'll proceed on that basis.
But this rule,
So if someone walks into the secretary's chamber claiming an education relaxation, wearing a color shirt which he likes, he will say, yes, we are relaxing. And if otherwise, he will say, we are not relaxing.
but according to the rules for Group D staff, he must be 8th standard.
Who is saying he must not be? Why are you making this unnecessary submission?
Then relaxation condition, who can run? In eligible cases.
Then who will be eligible? How you will examine whether this person is eligible for relaxation? Where is the guideline, SOP, any instruction in this regard? We have asked you. And after 10 minutes, we are back at the same position.
I have searched, kindly ask the department once again whether any other subsequent
Not today, it will come on Friday. No further opportunity will be given. Monday. Why? Okay. So not today. It is, since it is WPST, it will come on Monday.
Monday.
Grateful.
My lord, instead of Monday, my lord, any other day, my lord, Monday, I have some difficulty. I'm sorry, my lord. Any other day, no, Friday, hope na. My lord, instead of Monday, since your lordship last.
Tuesday?
Yes, any other day.
Monday with not today. Monday with a note, not today. It will take on.
Item number 21, 21 and 22.
My lord, I am for the petitioner in this matter.
My lord, I am appearing on behalf of Public Service Commission.
Okay. The matter pertaining to, my lord. Pertaining to the, my lord, regularization of the petitioner who are the temporary lecturer in the polytechnic colleges. My lord, on the last occasion, kindly recollect, my lord. My lord, your lordship was of the view that we have to place the relevant rules when the selection process was conducted. And my lord, the appointment of the petitioner after working interview, my lord, I take instruction and I have taken the instruction and I prepared a compilation of the rules.
Shared it with the.
No.
Please share it so that everybody knows what you are talking about.
May I file an affidavit to that effect?
Not required. Why
Okay.
affidavit?
Yes.
If these are rules and statutes,
yes.
affidavit is not required.
Yes, copy.
Because one issue, if we remember correctly, which arose is whether you are possessing the requisite qualification
in terms of the rules,
extant rules.
At that point of time.
So now you are relying on these. You give him a copy, let him go through it, and give a copy to the commission also. Who is here for the commission? You have no person here in courtroom.
Yes, my lord, my junior is there.
You are there.
My junior is there.
I shall give. I just one copy. I handed over a copy of.
So you will file it during course of the day.
Yes.
The learned advocate for. Then 21 and 22. Both.
Item number 23.
23, my lord, Mr. Jodas Patnaik appearing for the petitioner, my lord. He came to it, my lord, or from the way, my lord, after feeling unwell, he has returned home. MRI is done, my lord. That's why I'm praying before your lordship, not this week.
Not this week. I spread list after.
Item 24.
I'm praying for not today.
Why, sir?
My learned senior advocate appearing on another courtroom.
Appearing?
On another courtroom.
You start, he will come. WPST. All right. Very well. Not today. No order.
Well,
25.
Lordship, I'm praying for a week's accommodation on behalf of the petitioner. On the last occasion, Lordship directed us to file a reply to the affidavit in opposition filed by the respondent authorities. We were the petitioner who is to affirm the same. Sir, Lordship, she is unwell. For that reason, she is not able to come and affirm it.
As prayed by the
Item number 26.
Number 1, my lord. Matter pertains to compassionate appointment. The BL Sabu and Vijit Samanto were appearing on the petitioner. Myself was appearing for the respondent number 1 along with Mr. A.K. Rafti. It's a WPST matter, but the petitioners are not.
You are for?
The respondent number 1, my lord, Momi Das.
Private. Not today. Let us see what happens.
WPST matter, will it come up on Monday?
Obviously.
'27.
My lord, for item number 27, I'm praying for not this week, my lord.
What happened?
My lord, Advocate Bikash Ranjan Niyog is appearing in the matter. He's out of station, my lord. My lord keeps it any day next week, my lord.
Not today. We come on Monday.
Grateful, my lord.
28.
28, my lord, I am appearing for the state respondent.
My lord, I am for the applicant. There was a direction for filing exception. I am filing exception.
Not today. Exception is taken on record. Matter is adjourned.
29.
In this matter, Mr. Emin Roy is appearing, my lord. He was here. I don't know, my lord, where he has gone. List us today. Not today, my lord.
— 30.
My lord, 30, my lord.
Item number 30, I am appearing on behalf of Public Service Commission. My lord, since I am appearing virtually, my lord, I am seeking, I am praying that let the matter be fixed at 2 p.m. Then I will submit the affidavit, lordship.
Actually, we have fixed the matter for 2 p.m. It will continue for some time.
My
So
lord, it
not
was-
today. It will come on Monday.
My lord.
If it can
Oh.
wait till Monday.
Deeply.
31, I am for the petitioner. Last occasion, kindly see your lordship's order, my lord. They have not taken any steps, my lord. This order was communicated. My lord, in their assurance, my lord, your lordship adjourned this matter, my lord. My lord, kindly see the order, my lord, passed on, my lord, 3rd December 2025, my lord. Mr. Amol Kumar Sen, Lanet, AG, my lord, submit, my lord, they will take steps. Authority will expedite the issue and make all endeavor to complete the same. But till date, my lord, they have not taken any steps, my lord. Your lordship fix the matter as to be mentioned. I will communicate the order, your lordship.
What happened? Any progress? So now it is done.
Yes, but they have not
It
communicated.
is done. Relevant papers for superannuation pension, commutation, family pension with service book are sent for issuance of necessary admissibility report and for sanction of pension. It has been sent to the Accountant General.
Your lordship direct the accountant general to expedite them.
Sent to Accountant General. So nothing remains on your part now.
No. Duplicate service book prepared.
Yes, we see that with service book. You have said with service book in the second paragraph of
Lord,
this.
kindly have a look, my lord. Also, my lord, this 5th January letter also. My lord, Lord, kindly have a look. 5th January letter also. 5th January letter, my lord, issued from the Joint Secretary to the Government as well to the Additional Director of Agriculture.
Yes, service book has already been prepared, reconstructed. And that is why on 19th it has been sent.
Then, my lord, your lordship direct the response 6, my lord, the accountant general, my lord, A and E, my lord, to expedite the matter. My lord, petition is senior citizen, my lord.
Was the notice served on the Accountant General?
Yes, my lord, initially, I serve all the respondent, my lord, file affidavit service, my lord.
Oh yes, earlier he has appeared also. Respond number 8.
6. Accountant
Who
general.
is respond number 8?
Director of Agriculture. Accountant general.
8, no.
There is no 8.
No.
See the order of 19/11/2025.
Accountant general, accountant general. এই যে accountant.
এইটা
This is the notice matter to serve the accountant general, my lord. This is the original matter.
Normally who represents the accountant general?
আমি জানেন কি Your lordship passed one order, my lord. I will sign again, my lord, too. But
No, ask him if you can ask him to be here in the second half. This need not be kept pending. Why it should be
No,
kept?
there is no need. My lord can direct, my lord can dispose of the matter. There is no harm because everything we have forwarded them, so you can dispose of the same also. Service করেছেন তো।
Very well.
They will not, your lordship, make it pending, my lord, and my lord,
The-
just any order. Or
There appears
otherwise,
to
they
be
will
an
not
issue
take any steps, my lord. They will not take.
raised by the writ petitioner
Yes, ma'am.
that for want of his service book, his retiral dues were not being finalized.
এই যে
So OA now is also used
Yes. I'm sorry, my lord.
in view of in view of disposal of the writ petition.
Not I beg to appear for the petition.
Too, I am appearing for the state, my lord.
You filed a report.
I have filed report, my lord, on 3rd 12, 2025.
I'm seeking your lordship's leave to file our exception to that one.
How much time do you want?
My lord, it's ready, my lord. I'm seeking leave to file.
The
But I tried
exception to
to-
the report is taken on record.
But I tried to serve a copy upon my learned friend, my lord.
Exception to the report is taken.
Third 12, 2025, I served copy. There have no any liberty of your lordship for filing the exception. So I could not receive that. Now, my lord.
Copy of exception is served on the respondent's counsel.
Filed by my learned friend.
You have already seen.
No, my lord.
We are saying after 1 week. Yes.
Deep level lordship.
Third, 23rd.
33.
My lord, I'm praying not today.
Not.
Wait.
34. My lord, I am for the petition, my lord.
এফিডেভিট তো ফাইল হয়ে গেছে দর্শন রাজুয়া
My lord. 35. My lord, affidavit in reply, my lord.
Sir.
Sorry.
Affidavit in reply is being filed. One week.
In printer. Printer 35.
My lord, in 35, my lord, I'm beg to appear for the petition, my lord. Here's my affidavit in reply, my lord.
This is an opposition.
We have served our from the other side.
Reply কাকে দিয়েছেন?
Sir, আপনারা তো সার্ভ করে দিয়েছে স্যার।
কপি দাও।
Pleadings having exchanged today
Yeah. 36. 36, my lord, I am for the petitioner. My lord, your lordship directed to file opposition, but they have not filed opposition, my lord, till today. 36.
tenth and matter, my lord. No. Just now, my lord.
Opposition in affidavit in opposition.
So not 23rd.
Yes.
My lord, after 2 weeks, my lord. এক্ষুনি মুক্তালকে ফোন করে দে grateful your lord. 2nd March.
$37.
দেখো তো 41.
The 37 I'm for the period. On earlier occasion, your lordship directed to file supplementary affidavit that has been served upon this case.
হ্যাঁ অনেকদিন আগে করে দিচ্ছি
2019 it's a process by the public service. Commission is also a party. Have you served on the commission?
Yes, my lord, I am appearing on behalf of commission, my lord.
Conduct has been served.
Have you served on the commission?
Yes, I have served upon the learned advocate who is representing the commission.
I wrote a letter.
My lord, I am appearing on behalf of the commission, lordship.
Supplementary served on you.
No, এটা কাকে দিয়েছো? Commission
Has the supplementary been served?
But
No, my lord, supplementary, nothing being
only
served.
served upon the state, give both, not on the commission. এটা ভুল হলো.
Supplementary affidavit is being filed. It would be open to the respondents to file a reply if required, opposition if required.
সার্ভ করিস কেন এটা 38 ভাবলাম ভাবার কি জায়গায় পার্টি আছে সার্ভ করবে আলাদা অ্যাডভোকেট আছে আই এম গ্রেটফুল
I'm praying for not today.
For petitioner.
Petition.
But only thing, my lord, that pursuant to my lord's order, my lord, the affidavit in opposition is ready, and I shall also forward a copy in course of the day. If you also kindly, my lord, allow me to file this today, I can file it.
Today?
Opposition, yes.
The learned AAG.
Two weeks after. Second March. Second March, my lord.
Yes, when do you want?
After
10th.
I have to go to my daughter, son, mother, Hyderabad, for 4 days.
39.
My lord, I am for the petitioner.
Could I file my opposition?
My lord, advocate on record has not been come for duties illness, my lord. I have been instructed to file affidavit in reply, my lord, which I subsequently served, my lord.
Opposition is also filed today.
Yes, yes.
Opposition and
Lordship, I'm on behalf of the petitioner.
For the state response.
Lordship, petitioner before your lordship joined in service in the year 78 as constable, and he was placed under suspension with effect from 2/8/86 in connection with his arrest for involvement in Raniganj PS case number 2 of 1986 under section 396 and 2527 Arms Act. On the same cause of action, departmental proceeding was started, Lordship, initiated against the petitioner. And Lordship, the petitioner was released on bail on 14/12/87, but he was under suspension. As such, he could not join back his service. An order of withdrawal of suspension was passed on Lordship 9/4/2003. But the order was never communicated to the petitioner.
you are relying on which decision?
Lordship, that is on the Lordship. Kindly let me place the fact.
Sir, go through the order of the court of 9/12/25. We have recorded everything. You want to repeat everything.
No, Lordship, I don't.
So
want
therefore, show the judgment.
Lordship,
We have said we have all considered all these things. 7 years, 4 months service you have performed. You have not
Lordship,
performed.
What happened, Lordship? It has not noted. Your Lordship, on that day it was not submitted rightly, Lordship. Your Lordship, kindly hear me.
So what is missing from this order? Don't say everything. What is missing? Tell us.
I'm
Unnecessarily wastage of
I'm
time.
coming to that, Lordship.
Every day a new counsel will come and say that this was not placed properly. You did not appear on that day.
Lordship.
Then, today it was not submitted properly. There is nothing. Which judgment you are relying upon? You have not sought recall of that order that you are saying it is not properly submitted.
My lord, the order of suspension was not communicated as such. He has no knowledge about the order of Lordship withdrawal of suspension. As such, he could not join the service, Lordship.
Where has he said in the OA? Show from the OA where this statement is made.
OA, Lordship, here in OA, Lordship.
OA, he didn't remember.
No, Lordship. What I am submitting.
Where is it? Show from the OA. Don't make submission on fact which is not there in the record. Just because new advocate has come, therefore everything now has to be said afresh. Wonderful way of arguing a case. Any advocate who comes, he will be confined to the same pleadings. It will not give him a scope to say anything he wants.
I'm coming to the OA, Lordship.
बोला नहीं
But Lordship, in reply, they have stated, Lordship. In reply of this OA, the state respondent says, oh, Lordship, your Lordship kindly come to their reply, Lordship.
No, we will not look into. You show where you just now you said that it was not served. Where is that averment?
I'm
Don't try to unnecessarily take us through the records and waste time. Say something which is meaningful and fruitful.
No, it is not there, Lordship.
That's not your case, we know. Just because you were not here on the last day, that does not mean everything was not said properly. You are casting aspersion on your own friend.
No, Lordship, I am not.
You are at the very outset, you said it was not submitted properly.
Lordship, it is the fact, Lordship.
This kind of submission is not appreciated.
Lordship, it is fact that that was not served. Your Lordship kindly once come to their.
Will not look into anything. How can you say it is not proper? Did you file a recall of that order? We have recorded everything. Anything you can stand up and start submitting. Re-argue every date, re-argue. Next date, some other counsel will say, he will say same thing about you that you have not said anything properly. We should encourage this. Change of counsel on every day.
No,
You
not
say that the earlier counsel was
not
not
change
doing
of counsel, Lordship. On that day, I was absent, Lordship. That's why he submitted, Lordship.
You were not here, we remember. It was argued by someone else.
Lordship, correct.
There is nothing.
So, Lordship,
Just one thing you tell us, please. In view of his acquittal, can he be made to suffer the consequence?
He should not suffer, provided he is a person, my lord, who has obeyed the orders and has joined the service. He himself secluded himself from the service arena.
In that case, we were faced with the same issue. Therefore, this is also a case of a constable. That case was also a case of a constable. Where in the police regulation, this is covered. How the person is to be dealt with after acquittal in the criminal case. Under CCS, there is a provision that if based on the criminal prosecution he is dismissed, then after the acquittal, what is to be done? Where is the similar provision in the police regulation? Which provision covers this circumstance?
To my knowledge, I have not seen.
Then there is no provision.
In that event, my lord, and he has not made any, my lord, prayer for my lord.
He just wants pension. He just wants pension. Because he retired in 2013. 16. He was acquitted in 13, he retired in 16.
Acquitted in 13.
13 acquitted, retired in 16.
And approaches the, my lord, tribunal in 2022.
Without any cause of action. Where is the OA? What has he said?
It is at page 87. Please see the relief claim at 95.
Five. No, 96. Post-retirement benefit.
Page 96, my lord, relief claim.
Post-retirement benefit.
Section 21, whether he has filed any remedy has been exhausted or not. Nothing has been. You pass the order in the second half.
Yes, some remedy
Lordship, may I please?
The fixed matter will be taken up first, yes.
Item number 15.
Who is the petitioner? You are the petitioner.
Applicant is the state. This HON'BLE is appearing this matter, my lord.
Huh?
This HON'BLE is arguing.
No, it was for your submission. Both parties were to refer to judgments.
One thing I can point out to your lordships, because I raised that, I submitted rather, since your lordships going through the judgment impugned under appeal, that the merit cannot be a consideration. Then your lordship asked me to show from this latest judgment. Well, I'm showing that paragraphs 139 to 143 first. Page your lordships, pagination is not there. Online judgment. Page 48 at the top, very small letter. Paragraph 139.
Yes, we have 139.
Now I tell you.
However,
while substantial justice must be advanced, the law of limitation is equally binding, and sufficient cause must be shown in substance, not in empty form. This ensures the balance between the justice and certainty is not skewed in favor of unmerited litigants. 140. However, at the same time, the court must be mindful that the strong case on merit is no ground for condonation of delay. When an application for condonation is placed before the court, the inquiry is confined to whether sufficient cause has been demonstrated for not filing the appeal or proceeding within the prescribed period of limitation. The merits of the underlying case are wholly extraneous to this inquiry. If courts are to look into the merits of the matter at this stage, it would blur the boundaries between the preliminary procedural questions and substantive adjudication, thereby conflating two distinct stages of judicial inquiry. The purpose of Section 5 of the Limitation Act is not to determine whether the claim is legally or factually strong, but only whether the applicant has reasonable justification for the delay. 141 paragraph, the test of sufficient cause cannot be substituted by an examination of the merit of the case. Condonation of delay is a matter of discretion based on explanation for the delay, not on the prospects of success in the case. The merits are considered. A litigant with a stronger case may be favored with condonation despite negligence, while a weaker case may be rejected even if sufficient cause is made out. These would lead to an inequitable and inconsistent application of the law, undermining the uniform standard that the doctrine of limitation is designed to maintain. Then paragraph 142. Another practical reason why merit must not be considered at the stage of delay condonation is that it risks prejudicing the mind of the court against one party even before the matter is substantively heard. By glancing into merits prematurely, the court may inadvertently form a view that colors the fairness of subsequent adjudication. The judicial discipline required at this stage demands that only the cause of delay be scrutinized and nothing more. This ensures that the ultimate adjudication of rights occurs in a neutral and unprejudiced setting. The law of limitation is meant to apply uniformly across cases regardless of the intrinsic strength and weakness of the claims involved. To import merits into condonation proceedings would effectively dilute this uniformity. Then your losses again, paragraphs 256 to 259. Page 96, my lord. Last but three pages you lost. Paragraph 256 to 259. As far as the contention of the respondent number was is concerned, apropos to the merits of molding of relief by awarding compensation by the first appellate court, and the same is squarely answered by the principles encapsulated in Prothapati Shubha Reddy, wherein it was categorically mentioned that the court, considering a condonation of delay, ought not to go into the merits of the case as hand. We also wish to highlight that the High Court applied the legal position incorrectly in the impugned order and performed an exercise of merit hunting. It gave a prima facie relevance to the argument of the respondent number one on the grounds that the suit of the appellant was not at all maintainable in the first place. In paragraph 13 of the impugned order, the High Court recorded a semblance of right in favor of the respondent number one, swayed its mind to allow the condonation of delay, and it accepted the same as a sufficient cause. We hold such observation to be erroneous and expressly bad in law. Similar contention was rejected by this court in state of Madhya Pradesh versus Behrul, 2020-10 SCC 654, wherein the appellant state was seeking a condonation of delay of 663 days. The court sternly noted that it will not let the courts to be forums wherein the government can walk in when it desires, entirely ignoring the period of limitation, and buttress reliance on the case of this court where it allowed condonation and employing its discretionary powers on merits or modalities, peculiarities of those cases. Relevant paragraphs are extracted below. Para 3. No doubt some leeway is given for the government inefficiencies, but the sad part is that authorities keep on relying on judicial pronouncement for a period of time when technology had not advanced and a greater leeway was given to the government. Para 5. A preposterous proposition is sought to be propounded that if there is some merit in the case, the period of delay is to be given a go-by. If a case is good on merits, it will succeed in any case. It really a bar of limitation which can even shut out good cases. This does not, of course, take away the jurisdiction of the court in appropriate case to condone the delay. We are of the view that the aforesaid approach is being adopted in what we have categorized earlier as certificate cases. The object appears to be to obtain a certificate of dismissal from the Supreme Court to put a quietus to the issue, and thus say that nothing could be done because the highest court has dismissed the appeal. It is to complete this formality and save the skin of officers who may be at default that such process is followed. We have no earlier occasions also strongly deprecated such practice and process. There seems to be no improvement. The purpose of coming to this court is not to obtain such certificate. And if the government suffers losses, it is time when the officer concerned responsible for the same bears the consequences. The irony is that in none of the cases any action is taken against the officers who sit on the files and do nothing. It presumes that this court will condone the delay, and even in making submissions straightway, I will show in the facts of this case a irony part, straightway to the council, appeared to address on merits without referring even to the aspect of limitation as happened in this case, till we pointed out to the council that must first address us on the question of limitation. We are thus constrained to send a signal, and we propose to do in all matters today where there are such inordinate delays that the government or state authorities coming before us must pay for wastage of judicial time, which has its own value, and such costs cannot be recovered from the office, can be recovered from the officers responsible. The length of delay is a relevant matter which the court must take into consideration while considering whether delay should be condoned or not. From the tenor of the approach of the respondent, it appears that they want to fix their own period of limitation for instituting the proceedings for which law has prescribed a period of limitation. Once it is held that a party has lost its right to have the matter considered and merit because of his own inaction for a long, it cannot be presumed to be non-deliberate delay. And in such circumstances of the case, it cannot be heard to plead that substantial justice deserve to be preferred against technical considerations. While considering the plea for condonation of delay, the court must not start with the merits of the main matter. The court owes a duty to first ascertain the bona fides of the explanation offered by the party seeking condonation. It is only if the sufficient cause assigned by the litigant and the opposition of the other side is equally balanced, the court must bring into aid the merits of the matter for the purpose of condonation of delay. We are of the view that the question of limitation is not merely a technical consideration. The rules of limitations are based on principle of sound public policy and principles of equity. We should not keep the sword of Damocles hanging over the head of the respondent for indefinite period of time to be determined at the whims and fancies of you. So that's why I pointed out, you also pointed out on the day so us. On that day, it's a longest judgment, I could not point out to your lordships. Now kindly see what I'm saying on the irony. See our affidavit, I have taken your lordships to that. I am not taking the other judgments that referred to in this. I have brought it if you also Pothapoti Subba Reddy. The same point. Opposition. Opposition. Just kindly take up our opposition file. Reply I find the opposition. Why I am saying it, lordships, how negligent they are. Opposition. One thing, no explanation in any sort of. But kindly pay paragraph 9 of my affidavit in opposition. Back sheet will be Mr. Shokti Padojana. Page 9, your lordships. I placed it but for repetition, that's since I placing this judgment elaborately. Paragraph 9, page 9, your lordships. Judgment under appeal, kindly take note of that, your lordships. 20th November 2023. We communicated certified copy on 8th January 2024. And this is a communication on 30th January 2024 by one of the appellants to other appellants, highest body. Intimation regarding the court order for induction of such and such. This is to bring to your kind notice that Mr. Shokti Padojana, Advocate High Court, Calcutta, by Neil, dated 8th January 2024, has requested to take kind necessary action to comply with the order directed by the Honorable Justice, Calcutta High Court, related to case number for regarding implementation of West Bengal Health Scheme benefits to the employees of the Agricultural Training Institute, the photocopy. But even then, they did not take any step. And no explanation, your lordship. It's a contested matter.
And along with this, next paragraph says that the order is also enclosed.
Exactly.
Certified copy of the
Certified, I have I've given by 8 January. But certified copy takes time little. Nowadays, my lord, our court's judgment is website copy should be act. 2-3 judgments, your lordships. For the purpose of communication and act. So this is this, my lord, no explanation your lordships will find. Everywhere, my lord, mentioned review, memo of review, all that, your lordships.
Review.
Review. You kindly take up the application for condonation. Negligence at every stage. I'm not, my lord, accusing someone. Kindly, similar, kindly take up application for condonation of delay. That's the বলছি বডিতেও আছে why fear only there state to lordship page 30 prayer 8 this is also in the body also. Why should we blame the officers only, my lord? We are also at fault.
My lord, regarding this, may I be permitted to say something, my lord? My lord, on the last occasion, Mr. Samanto had already categorically pointed out that indeed this a fault from our side, from the learned advocate. And my lord, in the supplementary affidavit that we have filed, this has been acknowledged, my lord, and we have sought leave from your lordship to correct
Not
it.
this part.
Memorandum of review, yes, it is there. So,
Anyway, even if they had written an appeal,
That's I'm pointing out that
if they had written appeal,
now your lordships kindly see this part, my lord, I have left it for the capitulation, your lordships kindly have a look at it. One thing, your lordships, I just the very first paragraph 3 of the application. Well, all that we have learned, well, here your lordship condonation of delay, we have to be give the particulars and data.
yes,
That
you have made this submission on the last day.
When came to know, and all of them are appellate, your lordship, director and the principal secretary, all of them are appellate. Director, your lordships will find respondent appellant number 5, principal secretary respondent 2, appellant number 2, and they suppress that communication. That this was communicated, you could have come with clean hands. It's a discretionary relief they are asking for. You look, this is there is some mistake or some bona fide mistake, whatever they explain.
Yes.
But they do not do that. So this is not a case, the 356 days delay to be confident. These are my humble submissions.
The parties have made submissions on the Just a minute, Mr. Sanya. Let me give some other date. Keep it on.
Well, 20th, I have some difficulty with my junior will be there.
No, we are also having some difficulty. 27th, 26th, 26th, 27th, 26th.
Must.
Item number 40.
Should be pitted against the technical. Close the earlier judgment.
আমি রিকর্ড
Obviously, cost was eroded earlier. Still justice stronger. Stated. The cost was eroded. What happened, I don't know. Rejecting another part. Rejecting to see the bill. The biggest states took the same plea, same thing happened. Cannot be. Situation for the service. Yes. We will just sit over there and tell to fire delay. And then take some benefit from it. Expecting of text.
Yes. May I submit one thing?
Yes.
Your Lordship, kindly come to the order of the learned tribunal. That is the last page of the last annex. Para 3, Lordship. The applicant, while working as a constable in West Bengal Police, having such and such DAP Asansol line, was implicated in a criminal case being Raniganj Police Station case number 2 of 86, dated 2/8/86, under 396 of the Indian Penal Code. After being charge sheeted, he was suspended from service from 2/8/86. After completion of trial, the appellant acquittal from all charges by the learned additional district and sessions judge, first track, first court Asansol on 11/12/13. Thus acquitted, the appellant prayed for payment of all post-retiral benefit dues and benefit including pension by letter dated such and such, Lordship. The date of birth of the applicant being 4/8/56 is superannuated from his service on 31st/8/16. Having heard the learned counsel, after examination of the record of the trial, tribunal finds that the appellant joined in service 1978. He had been suspended with effect from 1986 after rendering service for 8 years and 25 days. Though his pension was officially withdrawn on, though his suspension was officially withdrawn on 9/4/2003, he neither joined his service nor claimed any allowance. As per existing rule, service period, Lordship, is less than 10 years. Lordship, his suspension was withdrawn in the year 2003. Up to that period, Lordship, he is entitled to get the benefit, service benefit, Lordship. This is my humble submission, Lordship. There are, because Lordship, there is no departmental proceeding, there is no punishment. Lordship is judgment, Lordship. Lordship is judgment, Lordship. Effective these. Dishonorable court, Lordship. Wherein, Lordship, he stated he is entitled to get the service benefit while he was under suspension. This is unreported judgment, Lordship. Another Supreme Court judgment is also there. Another Supreme Court judgment I have referred, Lordship. No, eternal.
Which other judgment?
It's Supreme Court judgment है.
Premnath Bali.
Lordship. Premnath Bali. Suspension period should be treated as in service.
Yes, these are the only.
Lordship. And Lordship, discharged from the case, Lordship, in year 2013 and retired from service in the year 2016, Lordship. There is no punishment, Lordship, no departmental proceeding, and
no work.
No work also. That is true, Lordship, no work. So, Lordship, that service should may be treated as absence from duty, Lordship.
Absence from duty.
Lordship, otherwise, Lordship, there is no punishment. They have taken no action against me for illegal absence. Nothing there, Lordship. And I have honorably acquitted, Lordship, from the criminal benefit of doubt. বলেনি আপনি দেখুন পড়ুন
Say anything. The earlier advocate did not submit properly. Now he will say anything.
No, Lordship. I'm
Whatever
sorry.
comes to his mind, he will say.
I'm sorry, Lordship.
Advocate
41. 41, my lord, I appear for the petitioner. My lord, this is the affidavit in reply in connection with the opposition that they have filed.
You are filing the reply.
I have served a copy, my lord. Well, this is a case, my lord, the petitioner before Lordship, my lord, was while serving as the executive engineer. My lord, he was served with a charge memo containing only 2 pages of memorandum of charges. My lord, thereafter,
He was submitted a charge memo
containing 2 pages, the only memorandum of charges under Rule 10. My lord, thereafter, a few days, my lord, a bunch of papers were handed over to him, my lord, with a note of the, my lord, the Deputy Secretary of State Vigilance Commission, where the draft charges have been made, the appointment of the IA and PO were made, and my lord, the list of documents which are to be relied upon. My lord, the witnesses, all were there, my lord, and it was entirely was served upon us. My lord, from the communication itself of the, my lord, the Deputy Secretary of State Vigilance Commission, it will be revealed, my lord, it's a draft charge. My lord, there is no signature of the disciplinary authority, nothing. My contention before your lordship, my lord, in this writ petition is this, my lord, that the authorities blindly follow the SVC. My lord, they have not, my lord, have applied their own mind, one part. The other part, that being the draft charge. My lord, how far a proceeding could be, my lord, taken out? And if your lordship takes up the, my lord, the charge itself, but it starts from page 34. My lord, these 2 pages were served when the envelope is also been enclosed here with, my lord, annexed here with, by which this was served. But these 2 pages. A memorandum dated 28th of May 2025. It says a statement of imputation misconduct in support of the article of charge is enclosed, annexed 2, a list of documents by which the list of witnesses by whom the article of charges are proposed to be sustained are enclosed at annexed 3 and 4. The petitioner's name is directed to submit 7 days of receipt of the memorandum written statement of defense to the inquiring authority and also state whether he desires to be heard in person. He is informed that an inquiry will be heard only in respect to the article of charges as are not been admitted. He should therefore specifically admit or deny the article of charge. See, such and such is further directed that if he does not submit a written statement of defense on or before this date specified in paragraph 2 above, or does not appear in person before the inquiring authority or otherwise fails to refuse to comply with the provisions of order, rules and directions issued in pursuance of Rule 10 of WBS CCA Rules 1971, the inquiring authority may hold the inquiry against him ex parte. My lord, now your lordship will turn page 36. My lord, this is the, my lord, the envelope which has been served. Now, page 37 is the, my lord, the list of documents, my lord, which was later on served upon me, my lord. My lord, this is a correspondence made by this Vigilance Commission. Your lordship also take note of the dates. My lord, the memorandum was issued, my lord, on 28th of May 2025, and this very document, which starts from page 37, my lord, it gives a, my lord, memo with a date is on 31st of January 2025. My lord, I may say, my lord, they have already put the, my lord, the cart before the horse. Now, my lord, your lordship can take note, my lord, what have they stated the State Vigilance Commission. My lord, this is a proposed, my lord, the subject itself is, my lord, makes it clear it's not a proper charge sheet. But the proposed departmental proceeding against the Shamidi Bhattacharya, Executive Engineer, Midnapur Division Director, presently posted Executive Arsenic Civil Division 2, PhD Director under Eastern Circle, PhD Director, Department of Public Health Engineering, Government of West Bengal. So, my lord, this is a proposal. Now, my lord, your lordship takes up, sir, I am directed to state that on receipt of the certain complaints against the above noted government employee anti-corruption rule of the commission made necessary investigation into the matter. On perusal of the report of the investigation and related documents, the commission is of the opinion that there are material for proceeding against the government employee departmentally under WBS CCA Rule 71. Accordingly, draft article, your lordship kindly take note. Accordingly, a draft article of charges along with its annexure have been prepared and following are sent herewith for taking necessary action. Article charge 1, annexure 1, statement of imputation of misconduct in support of article charge annexure 2, list of documents by which the list of witnesses by whom the article of charge is proposed to be sustained, annexure 3 and 4, copies of documents mentioned in the list as per annexure 3. The disciplinary authority of the government should, now your lordship kindly take note,
should first satisfy himself whether a prima facie case for departmental proceeding against a government employee under the provisions of the said rules on available materials, i.e. the copies of documents which are enclosed along with the statement of witnesses as mentioned in Annexure 3 and 4 and of the draft charges. Again, one of the word draft coming in, my lord. The disciplinary authority may seek the assistance of IO, investigating officer, EO, inquiring officer, see such and such and such and such, to apprise him to the contents and the perspective of the charges in relation to the relevant documents and other materials made available to him if and when such assistance is needed by him. However, the disciplinary authority may act in such manner in this regard so that necessary delay is avoided in taking the decision by him on the available facts of the material. If the disciplinary authority on the perusal of documents is satisfied there is a prima facie case of departmental proceeding against a government employee, he should serve the documents at 1 to 3.
Is there any material regarding the State Vigilance Commission yet?
Pardon, my lord, your lordship said, my lord, any material to show, my lord, what, my lord?
The scope of State Vigilance Commission. You remember we had raised this issue.
Yes, my lord, in one matter, my lord, Mr. Learned, Mr. Amol Sen was appearing, my lord, he has submitted one.
Let us see.
My lord, that document, in another matter, my lord, that was there, it's not here with me now at present.
But that is the only issue.
My lord, I must
see a use of word draft, whether it will have the effect of nullifying everything when it is communicated by the competent authority.
Yes,
that is one aspect of the matter. The other thing is, if it is a draft, what is required to be done in between submission of the draft and consideration by the disciplinary authority?
Yes,
so again, the issue becomes relevant. What is the scope of this vigilance commission?
Yes, I understand what you're falling from lordship. I understand. Lord, my humble submission, subject lordship, kindly, my lord. My lord, the proceedings are drawn under CCA rules. CCA rules makes it explicitly clear, my lord, is only the disciplinary authority who is to take the call. My lord, if there is a, I may say, a conflict between a rule and a memorandum issued by the government,
we don't know.
My lord,
That is not challenged before us. That memorandum has never been challenged, and we don't know whether it was issued under 309 proviso or by or otherwise. Therefore, we are asking you.
My lord, in that case, my lord, your lordship may take up this matter on Monday, my lord. I will have that document which was served upon me by Mr. Shane.
We have found a copy.
My lord, neither of us have that copy now, my lord.
You also don't have it.
Vigilance
vigilance manual.
Manual na vigilance.
Just see whether this is the correct document.
2012, yes, my lord. This was handed over to me, my lord. In another matter, my lord.
Let us see whether that is sufficient or there is something else. Let him, since it is being adjourned, let him see. He must have seen it at some time.
Some amendment has been made for this by this amendment.
So, what is the date of the charge memo?
My lord, that is, my lord, the charge memo dated, my lord, 28th of May. And my lord, the bunch of documents by which, my lord, that was given, that is 31st of January.
Which year?
My lord, 2025. Both are in 2025. My lord, one is, my lord, the charge memos of 28th May, and my lord, the imputations, everything is of 31st of January. My lord, that is, my lord, I may say, subject to lordship, kindly, my lord, everything was done, and my lord, 2 pages charge memo was served. My lord, this is where my lord, joined the issue. But this is not act of the discipline.
See, there are judgments on this point akin to this vigilance commission under certain service rules. There is a preliminary inquiry preceding the issuance of a charge memo.
Absolutely, my lord.
Wherever the disciplinary authority relies on documents in the preliminary inquiry, he is required to make it part of the charge memo so as to give an opportunity to it. There is substantial compliance of that. Everything which was before the commission has been given to you.
My lord, there are certain reports, those are not there. I must say, my lord, it's not there. I will also check it, my lord. With regard to this, my lord, let that be on Monday at the top. I don't mind, my lord, let that be on Monday. I have to also, my lord.
The other aspect is, in a preliminary inquiry, there is no opportunity.
Absolutely, my lord.
So here also, probably before the commission, you were not heard.
My lord, I don't think so, my lord. I have to take.
Therefore, we are saying, what is the scope of this commission? Since it is a body constituted by some notification, what is the scope? Why this question we asked on the last day? Now we are more, fortified in our view that we are required to see it. Please read paragraph 9 at page 39.
Yes, ma'am. The advice of the State Vigilance Commission and the letter should not be treated as a part of the proceeding file, and the advice has been given to disciplinary in strictest confidence for his consideration, just helping to reach him. My lord, this is what your lordship said, my lord. I understand, my lord. But my lord, let me go through, my lord. Let me come on Monday or
So
tomorrow.
this recommendation of the commission itself says don't make this part of the disciplinary proceeding.
But this is,
and they are making it.
But this has been given to me, my lord. This is, I cannot deny it. Or else, my lord, had that been 3 pages is not there, well, I may not be knowing even of this.
No, you have the disciplinary authority will never quote the commission's recommendation
and reference
number while serving the article of charge upon the impugned. So therefore, if there may be a bar in that notification.
Might be, my lord. But that will help me, my lord. Obviously, will help me.
So therefore, we don't know whether it will help you or not, but let us see.
We'll try. I will try anything, my lord, that helps me, my lord.
Because there are other matters coming up. We should decide it in this case.
Yes, Lord, let that be tomorrow, my lord, or day after tomorrow.
The Vigilance Commission will include under the Prevention of Corruption Act 1980. Prevention of Corruption Act shall be exclusively given to the Vigilance Commission. They give their report comes in favor, then FIR will be launched. And if the Vigilance Commission privacy appears, then the case for department proceeding, then the disciplinary authority which is the charge.
No, but then we don't know. See, you please read paragraph 9 at page 39. Why we want to see the commission's scope. Please read it once.
Advice and State Commission and should be treated as a part of the proceeding file. Advice given to the disciplinary authority in the strict confidence of this constitution just for helping if you reach in this case. The disciplinary authority
Will never quote the commission's recommendation, and you are giving it to him. So, is this bar founded on any provision in the notification? Therefore, we are saying that is the relevant consideration we'll have to see. Because if it is supplementing a rule made under the proviso to Article 309, then only it can be relied upon. If it is supplanting, then it cannot be relied upon. Perhaps that is why this Vigilance Commission has stated that never to be quoted, and you are giving it to him.
all the cases, Vigilance Commission can be actually started.
So for the first time, he has come raising this point. He has not dealt with the earlier cases. We are. I was so.
Well, I do have that copy of Mr. Shina's. I will get it.
He will get everything.
He is the government. Well, he must be getting everything.
He can get everything.
42.
My lord, for the petitioner, Mr. Uday Shankar Chattopadhyay is the arguing counsel in this matter, my lord. The respondents have already prepared their opposition and are going to file it today. I have also prepared the reply. I want to file it today. Lord, may the argument take place on the returnable date. This is my prayer. Reply.
Affidavit in opposition and reply.
4 weeks বলছে।
Deeply.
43. See, my lord, I am praying for an adjustment for on behalf of the petitioner, my lord. Last occasion, his lordship was pleased to- My lord, 2 weeks, my lord. For filing, my lord, the supplementary affidavit, my lord. Actually, due to illness of my client, my lord, we could not affirm it, my lord. Earlier, there is a liberty to file a supplementary affidavit.
Yes, my lord.
By which order? My lord, last order is there, my lord. Last order. January, my lord. On 17th December, it was my lord first. My lord. My lord, it has been ready, my lord. Due to illness of my client, my lord, he intend to come, my lord, next week as he instructed, my lord. That's why. I'm grateful.
Item number 44.
Lordship, in this matter, Mr. Senior Advocate Joydeep Kaur will be appearing. So I'm praying not this week only. Lordship.
I am appearing on behalf of state.
You are for the state. Not today.
Not.
If I
can be not this week.
But I beg to appear for the response. Behalf of state. My lord, he is saying number 37. It is not, it has not gone on record on the last occasion. Last occasion, the last order says that on the prayer of both the parties, it is adjourned. But on the last occasion, my lord, for non-service on some of the respondents, they took time. On non-service of the petition, on respondent number, Service completed lordship affidavit
Pro forma defendant number 2.
on last occasion.
So time was short. But kindly allow us to use an affidavit against this plot and
Against?
against it being on record, the pleadings my lord sees, and I am ready with the matter otherwise.
The pleading is there. It is.
So the tribunal has allowed my prayer on the ground, my lord, that the complaint for sexual harassment was filed after a period of 6 months. The section 9 proviso was made applicable, and my lord, the report of the ICC was set aside. The law now is very settled, my lord. Our honorable division bench, my lord, in 2025 1 CHN, in the case of Vishwabharati Vice Chancellor, which has been upheld by the Supreme Court, has made it clear that that limitation period has to be adhered to. Lord, the alleged incident is from September 21 to July 22, and the complaint was lodged on 5th January 23.
Which respondent, according to you, was not served?
Lord, that was told by them. That was informed by them. I am not there, the petitioners.
But you have opened your submission by saying that there was some
No,
efficiency in service. So we are asking you, according to you, who was not served?
Lord, it was submitted that to you, Mukherjee. The complainant was not perhaps served on the last day. Complaint did not appear.
Complainant is respondent number 3 or respondent number 2.
Yes, Lord, they have made respondent and pro forma respondent.
She was served, Lord.
But
She was served.
nobody appeared.
She was served. No, what about respondent number 1? Who is this?
But one, it is referred back because she transferred to another office, Lordship.
Therefore, it has to be served on her.
Yes, Lordship, served.
So when it was served?
It was served, Lordship.
Just now you said return, and then you are saying.
On last occasion, affidavit of service also filed before you, Lordship.
You are representing the respondent number 2.
I am representing Lala Mir, the original respondents. Kindly come to the cause title, page 2 once.
That is what we are looking at.
Lord, I am the petitioner in the tribunal. They have made me respondent number 1. And the
allegation was made against you
by P.U. Mukherjee, the complainant. Yes, now
and it was heard by respondent number 1.
Yes, the deputy superintendent, she was a member of the ICCI.
The respondent number 1 appeared, and the pro forma respondents 1 and 2, they have.
Last order, Lord, they did not appear as per the last order. Lord, I am ready with my matter, Lord. I have no issues, Lord, with regard to anything.
Now let us see whether there is any service.
That's পড়বে পরের দিন।
আচ্ছা আমার কপি আছে।
তো টাইপ কপি দিতে হবে, তো সে পড়তে পারবেন? পাসপোর্ট করে দিতে হবে।
ডিরেকশন দিতে করব। ডিরেকশন দিতে করব।
Where is the service?
Lordship,
কতগুলো ডকুমেন্ট বেঙ্গলিতে আছে, ঠিক করতে বলবেন, ঠিক করো, আমার দেখবো। From beginning number. Right. Filed on the petitioner is taken on paper.
Delivered to that district. No.
Is the service complete?
সার্ভিস কমপ্লিট হয়েছে? না না, এই এই এনার উপর সার্ভিস জাস্ট মে আই এনকোয়ার লর্ডশিপ কাইন্ডলি ম্যাডাম। ও সার্ভিস হয়েছে মানে আই এম টোল্ড দ্যাট ইয়েস upon the respondent P. Mukherjee, the data entry operator, already yes, service done. Does it appear from the your affidavit? Affidavit দিয়েছে? Affidavit of service ফাইল হয়েছে? তাতে বলা আছে? কপি আপনার কাছে নেই কেন? এখনই দেখা যেত।
Whether this affidavit can be taken to be a service, just have a look.
সার্ভিস না টেন্ডার হয়েছে, কোনটা হয়েছে?
Just see the averment in the affidavit.
দেখুন মানে জাস্ট এ মিনিট লর্ডশিপ।
Just read the averments in the affidavit. It says regarding return from respondent number 1. It does not say anything about the other two persons.
I'm sorry, I shouldn't have pointed this out, Lord.
You pointed out.
I'm sorry, Lord, I shouldn't have.
Registration of the employee went to Santoshpur Post
This was the issue on the last occasion, so
It was served on you.
December 9.
I have received
The affidavit of service.
No, that it's for the court only, Lord.
To the respondent, and the performer respondents. But on that, the said copy of writ application along with all has been returned to the advocate on record.
What about the other two?
From the address of the performer and the track report showing return to sender. That means return to you. After that, what happened? Again, service done.
And what about the other two? There is one Lala Mir, there is one Srimati so-and-so, and there is another Srimati so-and-so.
P. Mukherjee item delivered. P. Mukherjee item delivered.
But P. Mukherjee item delivered, but does it appear from your affidavit of service? My lord is very correct. Your affidavit of service shows that
No, from the document also we are not able to reconcile. We are just marking with pencil, but we are not able to match the number. That issue needs to be clarified.
Please, just a minute. May I tell Malad, it is our duty to satisfy your lordship that the service has been properly done. So Malad, may I pray before your lordship one thing, that let us come back again and after service again upon them. I think that should be the proper course, lordship, because and my lord,
I will record appearance of the first respondent.
With that averment.
You are appearing for the first respondent.
Yes, Lala Mir. Because the cause title is also, I made everyone a respondent.
Okay, please.
So the cause title is also a little defective.
Satisfy
the cause title.
See, you want to utilize this.
Return back.
This is Wendrilla, but you are appearing for Wendrilla.
No, he is not.
Oh, I see.
There are two respondent number 1.
That is what I was saying, that it is also defective. My lord sees the cause title in the tribunal.
Yes.
All of them were respondents. Now they have made them as proof here.
That is because
it should be number wise as per our rule 1, 2, and 3.
It should be 1, 2, and 3. It is confusing.
That's creating the confusion.
You come to page 2, Mr.
Yes, yes,
Sen.
yes, yes.
You have to rectify that. Why should it be a confusing cause title?
হ্যাঁ, আমি দেখেছি খেয়াল করেছি।
Just change the number. Make it 1, 2, 3 instead of 1, 1, 2.
আমাকে অ্যাড করলে 2, 3 হলেই সমস্যাটা মিটে যাবে।
I think because since Malad, no,
Because the first respondent is the petitioner before applicant before the tribunal.
Yes.
So 1, 2, 3 can be pro forma, 2 and 3 can be made pro forma or whatever. Or you should say respondent first set, respondent second set. Something has to be done, otherwise it is confusing.
এই দুটোই ওয়ান হয়ে গেছে না, এখানে প্রবলেম হয়ে গেছে।
We allow liberty to the learned.
Did copy or that's not required.
Make a corresponding correction. What is it?
এখানে বসে এখানে কারেকশনটা করে দেবেন, হ্যাঁ, এই অর্ডারের বেসিসে এখানে এটাকে 1, 2, 3 করে দেবেন।
Next মানে কবে হচ্ছে?
না, অর্ডারটা আগে পেয়ে নিই।
Then by tomorrow, instead of during course of the day, by tomorrow.
Matter would appear after 2 weeks.
2 weeks. Huh?
To be done by the department.
না না, এখানে বসে করে দিই না।
Why can't it be done here? I am also wondering. Why do you want to send to department? Right now they can do it right now during course of the day.
With the leave of the court, it is corrected.
Yes, yes.
Normally,
Yes,
what we
guided.
do is we write that with the leave of the honorable
Yes,
court
yes, yes.
by order dated so and so we correct.
It's a very normal procedure everywhere.
So it should be 1, 2, 3 in this.
1, 2, 3 or as you like, first
No,
set,
1, 2,
second
3.
set, whatever you
Let it be 1, 2, 3 and instead of pro forma respondent should be respondents.
তুমি এইটাকে কেটে দিও ওখানে প্রফর্মাটা কেটে দাও।
বুঝতে পারলেন? আপনি অরিজিনালে ওখানে ফাইলে শুনে দেখে নিন, এখানে এই 1 এর পর এই রেসপন্ডেন্টটা কেটে দেবেন, এটা 2 হবে, এটা 3 হবে, এখানে বাই
Item number 46
গ্রান্টেড বাই দি কোর্ট, আর এইখানে pro forma-টা কেটে দেবেন। বুঝতে পেরেছেন? আমি এখানে করে দিচ্ছি আপনাকে। এই দেখুন, আমি এখানে রেসপন্ডেন্ট কেটে দিলাম, এখানে 2 করলাম, কেটে এই দেখুন, দেখে এই কেটে করে দেবেন। আর শুনুন, আর এইখানে তাকানা দিকে, আর এইখানে pro forma-টা কেটে দেবেন, এইটা অনুযায়ী কেটে দেবেন। আর এইখানে উইথ দ্য লিভ অফ দ্য কোর্ট এই সাইডে করতে হবে। লিভ অফ দ্য কোর্ট অফিসার সই করে দেবেন। এখনই করবেন।
Malad, this is an application where Malad, the petitioner got a favorable order from the learned tribunal. Malad, thereafter the petitioner moved a contempt petition. And Malad,
there's some other writ petition filed.
I have checked it, Malad, with the Malad name pay party which is there on the website is there.
Last day we have recorded.
Malad, we couldn't find any Shopon Maji in 2026. Only Shopon Maji in only one matter is filed in 2026. It's a CAN. It's a CPAN. And Malad, in 2025 Shopon Maji, Dr. Shopon Maji is this petition. I couldn't find any Shopon Maji, Malad, at least while browsing the net.
There the petitioner will be state of West Bengal.
Absolutely. But if I give any of the names,
it will search
it will
the
search
database.
From the database of this High Court, I couldn't find Malad that name. But and your lordship will find 6.
The task initially Mr. Sopon was engaged to file a petition, but that we are returned the deed. Then when again the LR has been closed on 17 December 25 for granting approval for filing the
What happened?
Malad, nothing, Malad.
No, what is that? Just give the brief background.
The brief of the petitioner Malad sought Malad study leave. Now, Malad, he was not granted study leave on the pretext, Malad, that 333 officers were granted TR. My lord, after that order, I have annexed, my lord, so many doctors were given study leave, ignoring the petitioner. My lord, that compelled me to move the learned tribunal. Learned tribunal said, as because what the reasons you have shown, that 333 incumbents were given study leave, that cannot be given. In effect, my lord, you have given further officers, my lord, not the petitioner. My lord, the tribunal allowed my petition, asked them to, my lord, issue the study leave. My lord, within a period of 1 week. My lord, that was not done, my lord, that compelled me to file a contempt petition. My lord, thereafter, my lord, the tribunal becomes, my lord, there's memo, the learned members retired, my lord, the tribunal becomes non-functional, my lord, I have to approach the this honorable court.
The incident took place on 4th of February. All over High Court, Kerala and other states, this amendment of the Administrative Tribunal Act 2021 declared to otherwise by the Supreme Court by Justice Chief Justice just before retirement, when they managed all the tribunals, most of the states suffering the same problem because another Administrative Tribunal Act 21 declared to otherwise. They managed High Court, Calcutta High Court, now, I was placed before the Attorney General on 4th February, after the Attorney General filed that Government of India filed an application for transfer of the all the solution after declaration of this particular act.
Whatever it is, whether it is by virtue of any order passed somewhere or just administrative lethargy or whatever, if the tribunal is non-functional, we,
so that the solution can be made by the Supreme.
My lord, I had a talk, my lord, Mr. Dear Senior Advocate is appearing in this matter, my lord. What he said, my lord, I have not seen the instruction. What he said, my lord, a situation like this has happened in our court. My lord, a matter is pending before my lord Justice Krishna Rao, my lord, dealing with Group 9 matters. Exactly same issue has happened in the Kerala High Court. Now, my lord, the learned Attorney General has opined that as because the two high courts, two pending matters are pending before two different high courts, and if there are two different conflicting judgments are there, that will create more anomalies. So,
what is the issue pending?
My lord, my lord, what has happened, my lord, this Tribunal Reforms Act, which has been said to be, my lord, now is, my lord, unconstitutional by my lord Justice Gawai, as his lordship then was, on 19th of November. Now, my lord, from that day, my lord, the Tribunal Reforms Act by which the appointments were given, those are all said to be annulled. Now, my lord, in our case, my lord, 3 names.
What is pending before the single judge? That's what we are trying to
My lord, the appointment of the members.
Oh, for that a writ has been filed.
Yes, my lord. Now, my lord, that again same thing has been there in the Kerala High Court. So,
recommendation was made.
but no, pull this. 3 members, 3 judicial members and 1 administrative members recommendation was made. My lord, this is what Mr. Rai said me, my lord, to the government. Thereafter, the my lord Justice Gawai's judgments came. My lord, the Attorney General said, as because now it is unconstitutional, in term those names were sent in terms of the Reforms Act. The Reforms Act itself became unconstitutional by the Honorable Court's order. So, my lord, those names are practically of no consequence. Now, that matter is pending before my lord Justice Krishna Rao. But that is nothing to do with this matter, my lord. My matter is clear.
Well, we are proceeding because now our president gives an opinion. The file was placed before the Attorney General.
See, if the Reforms Act is already declared ultra vires, then appointment has to be as per the
No, my lord.
no, as per the Administrative Tribunals Act.
Earlier rule, my lord.
It is very simple.
No, because the recommendation was made under the Amendment Act.
See, that one thing is that it is not before us, but it is a very simple thing. You can complicate it as much as you want. If the Reforms Act is gone, it has to be done as per the existing act. There is no other procedure.
1985.
Then,
That's why the file was placed before the Attorney General.
so what for what the file is placed? You initiate action in accordance with the act. What need?
That direction comes from the Attorney General or from the Government of India.
After the Supreme Court's order, a direction is required from the law officer also.
No, the Attorney General file was placed because recommendation was made under the.
Whatever it is, once the Supreme Court has passed a judgment, what any law officer, however high he may be placed, what he will say?
So that the solution can be made.
What solution? There is no thing to be resolved. There is a statute holding the field. You have to go by it.
Then again, selection process
Has to be, unless the apex court in the judgment has said that pending should be carried forward, taken to its conclusion in accordance with the act. If not, then it has to be done afresh.
Those who are already appointed, they should not be transferred, they should be done by the earlier act. New appointment cannot be done unless a tribunal commission is formed.
So when the judgment is clear, then what any officer has to say about this? But that's not the issue here.
And if they confirm or not, they are still holding to the orders.
There may be a subject in your theory, subject will be 50.
এই যে আমাকে চিঠিতে যা লিখেছে তাই 6 তারিখে আপনি বলেছেন ফাইল হয়ে গেছে তাই তো বলছিল ভাই কেন বলছি এগুলো থেকে ফেব্রুয়ারি কত দরকার আছে 11
in the TR, if the TR is not helping them, study. Study. Same thing is said. Study 300 copies. Try to set it given. The order is not satisfied, you can see it in the right. Something conduct. He will appear on because he tend to see an RS code. So no writ petition filed till date. An order not complied. So therefore the judgment should not be implemented.
But one difficulty is not clear. We are basically the law 015.
Huh? But this is not a writ petition against the order. This is seeking compliance of the judge order, whether it is right, wrong, or whatever it is.
Yeah.
So compliance, why you have not complied? There is no stay, there is no writ petition, and there is no compliance. What is the date of the judgment?
The tribunal of 11th of August.
25.
2025. 4 months and the 2 months, 6 months apart. Today is 11, 6 months, exactly.
We are not in agreement with the decision of the tribunal, but it is a decision today. We have, I think, considered in one case, there can be no parity claimed in the matter of study leave and TR. One faculty may be having 100 people, one faculty may be having 2. How they will
say? Facility up to the age of 50 years.
No, but what they are doing is when TR is not applicable, they are going for study leave. So, whether this can be allowed, whether the doctor's individual excellence is more important or the government service is more important and serving the people is more important. We have decided in one case. Who was appearing?
I am not a people, I look at Dr. Shantanu Das, and we are going to give the share. This much I have not looked at.
Dr. Shantanu, that must be a decision of this point.
But because I have to come before worship period, I was doing other things. That I came to know, and they have to ask me, they said, they are this. This much I know. I do not know what
they will obviously, we knew that thing.
And the grounds of appeal was also placed.
But you have to comply. We are not here.
Then for a delegate, so that if some development takes place,
or what is the stand of the government?
Where is the tribunal judgment?
Page 128.
Yeah, Chinese. Chinese.
দু বছর তো
2 বছর ম্যাক্সিমাম 2 বছর।
ক বছর তো 3 বছরের কোর্স এমডিতে
আমার তো 1 বছর দিয়ে
হুম
সবাই তো দিয়েছে স্যার এটা তো লুকিয়ে দিচ্ছে পড়াশোনা করে কতক্ষণ দিন দিবি
আমাদেরকে ভাগ দেবে না
Perhaps in that case, Mr. D.N. Rao.
I am not appearing anymore.
Oh, now we remember. Perhaps Mr. Rao was. So he will know for sure.
But he doesn't know what I'm doing.
Report compliance. We are informed by the learned AGP.
কবে
How it can be 2 weeks?
Second March.
Second March may be not. Then let it be 9th. Second because third, fourth is holiday.
Third, fourth is the holiday.
Second, 9th March.
9th March.
Third, fourth holiday for things will be very dicey.
We will be here for sure, but we don't know about.
47, we're at 47 IAPA for the petitioner. The petitioner. That here, this is regarding my shortfall of service. But I am covered by your lordship's judgment, which was assailed before the Honorable Supreme Court, and the Honorable Supreme Court has affirmed my lord's view.
Yes, this is a matter in which repeatedly we are asking you why directly.
That the bench is not available. But your lordship is aware since September. But your lordship is also.
Sir, you are no quarrel on the bench. You are also aware.
No quarrel. Always in agreement.
You are not placing the judgment.
Yes.
Third adjournment. We
Which
are
one?
allowing every day, but based on a judgment.
Yes, Roger Matthew.
Yes, but you have not. Till now, you are only saying it is not available. We asked you on the last 2 days. We were expecting you to show that.
Roger Matthew and one Roger Matthew judgment, your lordship is aware. Now I am also pointing on one order passed by the Honorable Chief Justice in this regard, where against the order of the single bench, where writ petition was moved. The Honorable Single Bench dismissed the writ petition on the ground, but this is not the appropriate forum. You have to go to the tribunal. The Honorable Chief Justice Division Bench has interfered and said that if this is the system,
Before the single judge.
I have already filed. The tribunal has given me a time. So now I cannot withdraw and.
Chief Justice, where is his order? What does it say?
M22211 of 2025. 2025, but the order was passed on 19th of December 2025.
Does it say, please read?
But I am reading it for you, lordship.
Read the last part where it says.
Yes.
Excise department?
No.
Excise.
Now, in our considered opinion, this order dated 15 December 2025 cannot sustain judicial scrutiny for the simple reason that, as a rule of thumb, it cannot be said that recruitment process cannot be called in question for any reason whatsoever. Only after examining the ground raised, paragraph 6, raised by the appellants, showing illegality of the recruitment process and
9 and 10, sir.
Yes, I'm coming.
Yes.
Paragraph 6 first. Last 3 lines. Recruitment process, an opinion can be formed whether writ can be entertained or not. Secondly, if selection process pertaining to state government service, certainly its recruitment process can be called in question before the state tribunal. As per section so and so of the Administrative Tribunal Act 1985, the recruitment process can also be called in question before the tribunal. If the tribunal was not functional, it was obligatory on the part of this court to hear the matter, otherwise the party will be remediless. For this cumulative reason, we set aside the order at so, restored so. Registry is directed to release the WPA before the so. But here, it was a writ petition directly filed before this court. But in my case, we have approached the tribunal. Tribunal has granted me time because there is no judge. But to that aspect, if your lordship kindly consider the Roger Matthews judgment once. But it says practically, specifically it said that if there is no tribunal, the judge is not there, then this court is having the power to be approached. We are simply asking for pension. Your lordship division bench has categorically specified or directed the state government. Kindly have a look to the Tapan Mondol's judgment and the judgment order of the Honorable Supreme Court I have annexed.
May I update the today's situation? Just a few minutes before I have the first half. Court number 2, Justice Shogoda Bhattacharya is entertaining. Single bench is entertaining.
Yes, I know.
Not the division.
I know. But there, in that case,
the division bench to tribunal.
No, that's not the point. The point is, if the tribunal's jurisdiction has already been invoked, then whether they will go to the single bench or they
or
will
the division bench. That point is being decided by Justice Amrita Sen, as Advocate General is also addressing there.
because Rosa Matthews says they can move the writ court directly. So, but then if they have not moved directly, they have gone to the tribunal. Then
And now before you.
then what is to be done? That is what he said.
Exactly so.
Because he is aggrieved by the order of the tribunal which fixes his case after so much time when there is no further member.
Absolutely.
This is,
Questioning that one, I have come to this court.
but he has not challenged that order.
Yes, yes. But that I have annexed. But kindly have a look.
Kindly have a kindly place your prayer.
Oh,
there are so many things annexed, all are not challenged.
No. But date has been given in March. But the matter was filed and moved in November.
Therefore,
7th of November.
There are two options to you. His Lordship, the Honorable Chief Justice's order we have just seen. Either you could approach the regular service matter bench, or if you have come to the division bench, should the prayer be not made accordingly?
But
because there has to be some semblance of harmony in exercise of jurisdiction within the High Court. It cannot be that one division bench and single bench, everybody is hearing the same thing.
Well, when I filed this petition, that judgment of this single bench and this division bench of the Honorable Chief Justice was not there. Well, this matter was filed. Well, kindly have a look when the writ petition was filed.
As on date, when we are considering it, can we overlook the judgment of the coordinate bench?
No, cannot.
Therefore, it has to be given.
Absolutely. But what your lordship, it has been felt from your lordship that in that case, the petitioners directly approach the single bench, questioning the selection process. Now, here we approach the tribunal. The tribunal has given a date in March.
So, unless you are saying an order of the tribunal, or unless you are agreed by an order of the tribunal, can the division bench take it?
When there is no bench and we don't know when the bench will be formed, I am remediless because the same point they will take before the.
Not remediless.
Well, they will they will. The other side will take this point before the single bench that they have approached the tribunal. Now, then I have to withdraw the petition from the tribunal. That I cannot do because the registrar doesn't have the power to withdraw, to pass any order, only to give date. No. Registrar doesn't have the power to.
I am not. Register করে file করার পরও সৌগতি নিচ্ছে।
Anyway, you file an opposition.
For
decision that you are relying upon, you have allowed the pension treating the entire past service as qualifying service.
Well, I could not hear
the judgment that you are relying upon.
This is regarding recruitment process.
Oh, this one.
Yes, of the Honorable Chief Justice. This is regarding recruitment process, and this is regarding pension.
The judgment that you are relying upon in this case,
shortfall of service.
In that, what have we held?
Condoning the shortfall. My Lord's judgment I have annexed.
Oh,
page 110.
It is within that 6 month or 3 months.
Yes. 110.
110.
Then they must have an opportunity. We can't pass an order like
that. They went to the Supreme Court and Supreme Court has
let affidavit in opposition be filed.
Pension.
Yes.
3 times I approached various tribunals and the High Court.
Call the next case.
Following March.
You want us to proceed without giving them an opportunity? Seriously.
May I say only one thing?
No, you may not. We are not.
They approached the Honorable Supreme Court and Supreme Court has. The
Sir,
affirmative
counsel, this is your case. You are saying it is covered by a case. Whether they are required to be given an opportunity or we should just pass the order like this. That is all we are saying.
Your lordship kindly allows me for 2-3 minutes. then?
Yes.
Kindly.
We have understood what you are saying. They have chased it to the Supreme Court. They have suffered a judgment now. So therefore, every case we should now just pass an order.
Kindly allow me to place the records first.
Unless they file an opposition, where is the question of the court proceeding further?
But in that case also, my lord
They did not file. They did not file an opposition in the.
No. My lord did not ask for.
In which case?
This judgment, which I am relying on.
Maybe. We don't know. That we are dealing with this case.
May I be given the liberty to place the petition for 2-3 minutes?
Not
Person is
without
starving.
Not without opposition. We will not proceed. If we have done it, we don't.
Your lordship knows what is the fate of the hearing matters.
See, we know all the fate of all the cases because we are writing the judgment. That does not mean that we will proceed without giving an opportunity to anyone. That is a basic requirement. You are insisting that without giving an opportunity of opposition.
I will never stand in the way. But the thing is, the person is starving. He is not getting pension. And the issue has
said that 4 times today that he is starving.
But kindly say
that cannot be a ground. That cannot be a ground to overlook a requirement of giving an opportunity. That cannot be a ground.
But they have passed the result.
Starving, whether you are starving for their fault or not, has to be determined.
But they have passed the reasoned order. So, but the opposition cannot improve the reasoned order.
We don't know.
The reasoned order was under challenge before the tribunal.
We don't know. And they have not filed.
I request your lordship to see the records
after opposition. We understood what you are saying. There is a shortfall. It is within the condonable limits. That is what you are going to see.
Then what they will file, what opposition they will, how they will.
Without opportunity, we will not pass an order. We will not. It may appear very obvious to you and it appears quite obvious to us also. But there is requirement of giving an opportunity.
But they are not asking for. But your lordship kindly allows me for few minutes. May I request
you? We'll give them an opportunity. Without that, we will not pass an order. Call the next case.
Next is same.
Item number 48.
Same. File an opposition in that case also.
They have filed a report here.
Already. In the second case. Then that we can take up.
Yes. Gopal Chakra. This report was handed over to your lordship. First page of the report.
11-12-25.
11-12-25. By the Executive Officer 1. Column number 3.
Who is for the state?
Shortfall of 12 days.
Only?
Yes. Column number 3. In the report, they have also annexed the reasoned order. Last 2 pages. Apnader report. No. 48 Gopal Chakraborty.
Who is appearing? Who is appearing?
Mukherjee appeared.
Tapan Mukherjee. Just now he was here.
48.
We'll take it up on Friday then. Not
Friday?
Not today. Just not today. No orders.
But here I have something to say.
Yes.
12 days shortfall.
Yes, we'll see whether it is 12 or days.
Actually, I'm seeing them. I'm getting phone calls every day. May I submit the affidavit service?
Yes, please. Why don't you keep it? We don't want to pass any order today.
Oh, very good.
Not today, you file it on the next.
On Friday. Or may I come back tomorrow?
No, tomorrow it will not come. It is WPSC, it will come on Monday, not Friday.
Monday? May I get a chance? One matter. At 2 p.m.
At the top of the list.
Fine, I'm grateful. I'm grateful.
Solo.
49.
And appearing on behalf of the petitioner, kindly praying for not today due to health ground of my senior.
Item number 50.
No, I am also praying for not today, Malad, today. I am praying not today, Malad. I am for the petition.
51.
Yes.
Last occasion, there is a direction to file affidavit. Today, I got it. What is it? My lord, then my lord, today I receive it. 1 week adjournment, and I have to file exception or reply.
And after
$52.
Not today. Nobody for the.
In this matter, my lord, additional advocate general is leading me. My lord, I am praying for 1 day accommodation.
any objection?
My lord, I am the respondent, my lord.
Any objection?
I don't have any. Your lordship may kindly fix this matter because, my lord, they have not complied with the order. I took out a contempt application. Thereafter, my lord, they have filed this petition after 1 year. And it's a fight between, my lord, two wives claiming but the state has come. Yes, two wives claiming to
Retiral dues. Retiral dues or terminal dues?
Retiral dues. Retiral dues.
The learned advocates representing the parties.
May I come at 2 o'clock on 16th March? 2 p.m. At 2 p.m. Grateful.
Before, my lord, I am for the state, my lord. I am led by government pleader, my lord. As per your lordship's direction, we are filing this affidavit, my lord. The copy has been already served. My lord, filing a reply, my lord. My lord, though is a delay in filing, may I serve a copy upon my learned friend?
Yes, you may. The affidavit in opposition.
Prepare a paper book. My lord, I will do it. It's a short matter, my lord. Very few pages, my lord. Even if we'll file.
55.
This way, activate service. একটা জেরক্স দিতে হবে এটা আমি
Which for the state. Yes.
In this matter, Lordship, the applicant or the petitioner appointed in the year 2010. Since 2000,
Before the tribunal, you agreed to appear for the typing test.
Lordship, that I bow down to your Lordship's consideration.
Now, therefore, can you maintain a writ petition?
No, Lordship. First of all, on the earlier occasion when the previous OA was filed.
That matter is not before us.
No, Lordship.
The order which is before us records your agreement that you are to appear for the typing test.
But
now that consent order you have challenged in a writ petition. Now tell us about the maintainability, then anything else. Then anything else after that.
Lordship, the fact is that I am agreed to sit on the typing test. Lordship.
Then why are you here?
But Lordship, the fact is that my such consideration was
Sir,
never
the
considered.
the point is a consent order you are challenging before the High Court. Overcome that difficulty, you may say whatever else you want. Don't try to skip that point. Address that issue.
I bow down to your Lordship. If your Lordship direct the respondent authority to conduct the type test by 1 month or 2 months, I will definitely act.
And if they do it after 3 months, you will not.
No. As per your Lordship.
What is this? What kind of direction you are seeking?
Lordship, otherwise, they will never consider my.
That's all then. Yes, take down.
Otherwise, they will never consider my
P6.
P6, I am appearing on behalf of the petitioner, my lord. My lord, I am seeking leave because after filing this writ petition, there are lots of chain of events was happened, my lord, that had to be annexed with my writ petition, my lord. I am seeking leave to withdraw the writ petition. And my lord, I take the instruction from my client, but I have the soft copy of that. I am praying not today to produce the letter before your lordship on the next date of the
Tomorrow to be mentioned.
Yes.
Yeah,
Grateful.
tomorrow to be mentioned.
Composite writ petition filed.
Now we tries. Wait, wait.
After court, my lord.
For that side, it's never enough. From that side, it's never enough.
After court.
Regular dose of vitamin N, then how why will
Yes, my lord, I will not say.
Lordship, with regards to item number 55, we were not able to file the affidavit of service. Maybe reflected in grateful. Your Honor.
Permit me, to jump the queue, my lord. 58 minutes may be taken. The state was supposed to file affidavit.
Who is for this?
Government present.
Anybody on his behalf here?